of any complaint lodged by the Honorable Lady Justice Miners. But that question, Mr. Speaker, also tells you why this is an impeachable offense. Those who know our constitution of theory say judges hold neither sword nor the past. The reason our constitution protects judges and puts them in a special place is because unlike politicians and the executive, they have no way and no forum of dealing with harassment from the political branches of government. But if we are wrong in that, Mr. Speaker, again why I'm very happy with this question, let's accept for argument's sake that indeed Justice Maina could have lodged a complaint, because it's possible she would have walked to a police station, met an OCS there, recorded a complaint and a statement. Dr. Muno has been here as a junior officer. The practicalities of an OCS, a police constable, summoning the Deputy President of the Republic to respond to a complaint. The whole spectrum from autographing, taking fingerprints, processing the Deputy President to take him to the magistrate's court to answer to a criminal offense would subject that office to so much indignity. And because the design of our constitution is that people holding certain offices, in fact the constitution offense is that they should behave in a manner that brings honor and dignity to the office. It is to save the country the drama, the spectacle of a junior police officer, a junior prosecutor, harassing, arresting, prosecuting, and because we don't want to subject our democracy to this kind of showbiz. That is why this Senate is vested with the power of impeachment, and that is why our Supreme Court has said several times, as I pointed out yesterday, the test is not whether he is criminally liable or civilly liable, which is the business of the division. I so submit, Mrs. Speaker.
It is true that this witness was called pursuant to a summons of the Senate, but normally a witness is called to produce a particular document or to produce a particular item. As we stand now, none of us knows what this witness is coming to produce. We can't even pull it out of these massive documents. We want to go on record that this is travel by ambush. We will know for the first time what this witness has come here to do when he is speaking. I know that was record, but before he starts, I want him to tell us what documents this witness wants to rely on, so that against all the evidence we have witnessed, at least we can have some semblance of looking at it. Thank you, Mr. Speaker.
The documents to be identified by the witness are contained in the over. in volume 8A of our bundle.
Calling the witness, please.
Does it stand here or it stands the other side?
Just have the witness on this side,
Okay.
where the others took the oath. Now, just to remind Counsel for the National Assembly, you have 20 minutes to conclude on your case, and the Counsel for the Deputy President, you still have your 45 minutes intact for purposes of cross-examination. Let's proceed.
Thank you, Mr. Speaker. I intend to use 15 minutes to take the witness in chief and reserve 5 minutes for any.
So before the witness takes an oath, Counsel for the Deputy President, you do confirm now that you understand and you know the documents that the witness is going to produce as contained in volume 8A. And these are the documents, I believe, in respect to which I made a ruling yesterday, to have them admitted.
We do, Mheshimiwa Speaker.
Thank you so much, Senior Counsel.
Yeah, thank you.
Thank you. So this is, we cannot, and as a chair, I cannot allow trial by ambush. Proceed.
Thank you. I, Abdi Ahmed Mahmoud, do solemnly swear that the evidence that I shall give before this Senate in respect of the matters before the Senate shall be the truth, the whole truth, and nothing but the truth, so help me God. Thank you.
So, Mr. Abdi, introduce yourself to the Senate, the place you work, your rank, and how many years you've worked in that institution.
Thank you. My name is Abdi Mahmoud. I'm the Deputy Chief Executive Officer of the Ethics and Anti-Corruption Commission. I have worked at the Commission since 2005. I started off as a senior investigator. Right now, I'm the Deputy Chief Executive Officer. My main responsibilities are to assist the Chief Executive Officer of the Commission in the day-to-day running of the Commission, among others. Another key role and responsibility that I hold at the Commission is that I chair the Commission Management Committee on Investigation Evaluation. Basically, I have been an investigator since 2005 when I joined the Commission. Thank you.
Thank you, Mr. Mahmoud. You are before the Senate this morning following summonses which were issued to your institution. And in the summonses, the 3 areas were identified. Would you wish to appraise the Senate on those 3 areas which you are to guide the Senate on?
Okay. If I may refer to my documents, that's
yes, you can.
Thank you. So there are three areas that I was requested to comment on. The first one is an investigation that the Commission conducted on a procurement on the supply of long-lasting insecticide nets at the Kenya Medical Supplies Agency, KEMSA. The second issue that I was to comment on is the declaration of gifts and donations received by His Excellency Rigathi Gachagua, the Deputy President, during his tenure of the office to date, pursuant to Section 14(5) of the Leadership and Integrity Act. The third issue that I was to comment on is the declaration of conflict of interest made to the Ethics and Anti-Corruption Commission by His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to date.
So we'll go to the first question, or the first issue, which you are asked to address yourself to. And I wish to refer the witness, Honorable Speaker, to our bundle 8 of our document. Can you identify the document at page 3 of that document?
Yes, I can identify. This is a letter that we did to the Clerk of the National Assembly on 23rd September 2024. It was responding to a letter that we received from the National Assembly requesting us to furnish the National Assembly with information on the investigation that we conducted on the long-lasting insecticide nets, and to indicate in our responses any outcome or status of the investigation that we did conduct.
So your letter in that volume relates to procurement of certain items at KEMSA. Am I correct?
You are correct.
You have appraised the Senate, the National Assembly in that letter. Would you appraise the Senate on its content?
The content is the procurement of long-lasting insecticides by KEMSA. This was in the year 2023, and the Commission, in its functions, either it conducts investigation on its own motion or at the instigation of other parties. For this particular investigation, we did receive a letter from the CS, who was then in charge of the Ministry of Health, indicating that there were certain irregularities in a procurement of insecticide nets by the KEMSA, and the CS then wanted us to conduct investigation and find out whether certain procurement irregularities did take place. And from that, we actually did carry out investigation, and the outcome of the investigation so far is already reflected in the letter that we have provided.
And what was the outcome of the investigations, Mr. Mahmoud?
There were serious procurement challenges that affected that particular tender. The major one was change of specifications to suit a company called Shobika Impex Limited, which was having which had a local agent by the name Crystal Kenya Limited that had the sole responsibility, or rather the sole function, to provide certain mosquitoes that had certain chemicals. So basically what the investigation concluded is that there are two types of chemicals that were used on these particular nets. If I may read one of them, one is called Synergist Piperolin Butoxide, PBO, long-lasting insecticides nets, while the other one is pyrethroid, long-lasting insecticide nets. So this company had the sole distribution rights on this particular chemical called PPO. And in totality, from the investigation, we realized that the PS at that particular time did write to the CEO of KEMSA, instigating or rather compelling the CEO of KEMSA to change the specifications so that it can fit the chemical that was to be provided by Shobika Impex Limited, whose local agent was Crystal Kenya Limited. Basically, that was the starting point. The other problem was that there was when the tender was to close on 23rd, the company, this is Shobika Impex Limited, at that particular time wanted to have a bid bond introduced into the documents, into the tender documents. Yet we all know that in procurement, the tender document, the bid bond is supposed to be part of the tender document. They're supposed to be delivered together. But in this circumstance, the bid bond was delivered by hand to the CEO's office on 23rd, when the tender was supposed to close. So they had to find a way of extending the period of closure up to 10th of the next month of March, so that that particular bid bond, which had issues, can now be factored in, or rather regularized, and so that this company called Shobika could benefit out of that particular extension. Of course, there are many other issues. Like, we also realized that at the end of the, when the tender was discontinued, for example, there is a company called Tianjin Yorkol International Trading Company that was among the bidders that initially bidded for this particular tender. They were disqualified on a fact that they were not authorized by a manufacturer. This company had provided sufficient evidence and proof that they're actually manufacturers. So a company that is a manufacturer was disqualified on the ground that they did not provide authorization from a manufacturer, yet they are actually manufacturers. So those are some of the challenges that the tender had. And
at the end of it all, what became of this tender?
At the end of what happened is, after the technical committee of the KEMSA did recommend Shobika to be awarded the tender, because this tender was actually was being financed by Global Fund. So the agreement was, after the tender evaluation committee's report is done, that report is to be handed over to Global Fund, the financiers. So when that report was surrendered or handed over to the Global Fund realized...
You said the evaluation committee of KEMSA
yes,
made a recommendation that Shobika be awarded.
That was the finding. That was the finding of KEMSA. That was the recommendation by the technical committee.
What happened next?
What happened is Global Fund decided to terminate the tender and asked an internal firm, or rather an internal organization called Wombo.org, which is the procuring arm of Global Fund, to do the procurement. And eventually, one of the companies that were actually disqualified because they were not authorized by a manufacturer ended up winning that tender, together with another firm called A to Z Textile Mills Limited. So those were the eventual winners, but that was after the termination of the recommendation by the technical committee of KEMSA.
So, just to clarify to the Senate, a company which had been disqualified by KEMSA ended up being the supplier.
That is correct.
Following the process which was undertaken by Global Bank.
That is correct.
Okay. What became of the bid bond?
Well, when we were investigating this, when the investigation was ongoing, we collected all the bid bonds of the firms that actually bidded, so that not only the bid bonds, but all the documents that related to the tender, so that we could evaluate and record statements. Now, the one that had issues was this one for Shobika. But when the tender was terminated, ordinarily, there would be no need to hold onto tenders or onto documents submitted by the tenderers, and they're usually returned. But for this particular one, because it was a questioned document, the CEO of KEMSA wrote to the ESCC requesting for that document to be handed over. And eventually we did hand over the document to him after recommending disciplinary action against all the officers who were involved in the tendering process, starting with the CEO, the technical committee members, the head of procurement entity. For this particular document, we have a certified copy, which we collected in case there would be need to reopen the investigation, because there could have been other offenses that could, come out of the investigation.
Did you hand over the bid bonds for the other companies which had participated in this?
They were returned to KEMSA.
They were returned to KEMSA. Yeah. Let's go to the second issue, which was identified in your invite, and probably we should start with the third one, which relates to conflict of interest by state officers and public officers. You are a long-serving officer of the Ethics and Anti-Corruption Commission. I suppose you are familiar with conflict of interest in terms of the constitutional, statutory, and regulatory procedures. Would you appraise the Senate on that aspect?
Okay, thank you. So conflict of interest is actually addressed under Section 16 of the Leadership and Integrity Act, and it clearly states that a state officer or a public officer shall use the best efforts to avoid being in a situation where personal interests conflict or appear to conflict with the state officers or public officers' official duties. Now, when we talk of personal interest, we look at Section 6, which explains or rather indicates the personal interest includes interest of spouse, child, business associates, agents, or any other matter in which the state officer or public officer has a direct or indirect pecuniary interest. Basically, in practice, what happens is we also have the regulation, which is the subsidiary law of that particular act. If we look at the conflict of interest, that particular part 3 of the leadership and integrity regulations clearly specifies how conflict of interest are supposed to be dealt with by public officers.
And in summary, how are state officers to deal with questions of conflict?
All public institutions are actually required to maintain a conflict of interest registers, which can be inspected by individuals upon application. That is the starting point. If, for example, a public officer or a state officer feels that he is conflicted, he is supposed to declare the conflict in that particular register. And you know, the commission also has a role in that the commission is actually mandated to enforce and implement the Leadership and Integrity Act together with the regulations.
Thank you, Mr. Mahmood. And if you say it, I hear you correctly say that conflict of interest extends to children, spouses, and business associates. Did I hear you correctly?
That is correct. That is subsection 6, section 16.
Let's go to the third issue in view of time, which is in relation to gifts.
Okay, gifts. If you look at section 14 of the Leadership and Integrity Act, together with section 5 of the regulations of the same act, it is clearly indicated that gifts received by a public officer is a donation to the state. That is what Regulation 5 indicates. If you go down there, you will also see that a state officer or public officer who receives a gift whose value exceeds 20,000 Kenya shillings shall, within 48 hours of reporting to the office, surrender it to the public entity in which the officer is employed. It also goes further in subsection 4 to indicate that a state officer or a public officer who receives a gift in terms of this regulation shall, irrespective of the monetary value of the gift, declare the gift received to public entity which the public officer represents. Finally,
all gifts are supposed to be declared, regardless of its monetary value.
Yeah, maybe, yes, that is correct. But what I maybe should have mentioned is that public officers and state officers are barred to receive any monetary gift. So here we are dealing with gifts that are not non-monetary. For monetary, they are barred, or rather we are barred from receiving any monetary gift. But yeah, so this.
And in the same manner, with respect to conflict of interest, we have a register of conflict of interest. Do we have a register of gifts?
Yes, we have a register of benefits in each and every public agency where officers who receive gifts are supposed to declare immediately, and we have indicated in 48 hours. And what I would also wish to mention is that
what is the role of the Commission in relation to gifts?
Okay. Yeah, now if you look at subsection 9 of the regulations, you will see that if a public entity shall, at the close of every financial year, furnish the Commission with a report specifying, and all the gifts, any gift the entity intends to dispose of, all that. And then subsection 3, of course, talks about report. The report under paragraph 1 shall be submitted to the Commission within 30 days after the close of the financial year.
So just so that we can close on that, every financial year, the Commission is supposed to receive the registers of gifts from all state entities.
That is correct.
For your record.
Yeah.
Have you received the register of gifts from the Office of the Deputy President?
Not to my knowledge.
Not to your knowledge. That will be all, Mr. Speaker.
Counsel for the Deputy President, you may now proceed to cross-examine the witness.
Thank you very kindly, Mr. Speaker, sir. I'll be very brief with you. You did receive the summons this morning, yes?
I received the summons yesterday afternoon.
And you had to come and testify in respect to what aspect in the motion of impeachment?
There were 3 items,
yes,
which I listed.
Kindly grab your notice of impeachment, the motion.
The motion?
Yeah, the motion of impeachment at volume 1 of the National Assembly.
If you insist.
And as you do so, kindly again repeat or state the thematic areas you are supposed to testify in respect to.
So let me start off by looking at the summons which I received yesterday. So the first one, the investigation of the Ethics and Anti-Corruption Commission of tender. The number is given there.
Thank you. Now let's go to that particular tender. What is the grievance in the notice of motion with respect to that tender? What is the mover of the motion aggrieved with?
Which
With
page?
respect to the tender you're testifying.
Which page?
What is the mover of the motion aggrieved with in respect to this tender of KEMSA? It's a simple question. You don't need to refer.
But I need to refer to the document, isn't it? So that I can read the exact.
It's okay, you can be led by your counsel.
Yeah.
You know the motion better than the witness who's been brought to test on a particular aspect. If you can just take him there so that
Let's go to...
we save on time.
Thank you. Just tell me the page, I'll be able to...
You page 24?
Page 24.
Yes.
Page 24.
You reckon that the mover is aggrieved by indicating that the deputy president bullied him and exerted unnecessary pressure in respect to this tender, correct?
As per the document, yes.
That is the position, correct?
That is what is captured here, but that is not part of my evidence.
That is not part of your evidence. Yeah. Does your evidence relate to the notice of motion, to the notice of impeachment before this assembly?
It does, but
is there a complaint in the notice of impeachment that relates to conflict of interest that you know of?
And so what I would really request you, let us deal with my evidence.
Yes,
don't take me to the evidence.
We are dealing with it. Is there a complaint that relates to conflict of interest in the notice of motion? If yes, kindly point it out for the assembly to note.
No, I wouldn't know because I haven't gone through the whole...
You have not gone through the motion.
The whole motion I've done.
Is there a complaint that relates to gifts and how gifts must be dealt with?
I want to...
Do you know or you do not know, Mr. Witness?
I do not know.
You do not know?
Yes.
Now, in respect to this tender, are you aware that this Senate sat and conducted an independent investigation in that respect?
I'm not even aware.
Are you aware?
I'm only aware of the investigation ESCC conducted.
Yeah. So in respect to this motion that is before the assembly, what investigation did you conduct that relates to the gift in this assembly?
I was requested to talk about...
We are talking about the notice of impeachment before the assembly, Mr. Witness.
I'm referring to the summons that I was given by this House.
And your summons must relate to the proceedings, correct?
I'm not the originator of the summons. How would I know how it relates? I will confine myself to the summons. And there are three issues I was to address. One of them is gifts.
How many companies bidded in that particular process?
I think there were about 17.
There were about 17.
Yes.
Did all the bids pass?
Pass in terms of award?
Yes.
Finally, the award was given to two companies.
Yes. Which companies were they?
Let me get the names. Yeah, the two companies that eventually won after the Global Fund conducted their own tender.
Yes.
One is called Tianjin Yerkol International Trading Company
Limited. Mr. Witness. Yes.
The other one is A to Z.
Do you know what led to the cancellation of the tender?
I know.
Yes, what led to the cancellation of the tender?
It was direct favorism to Shobika.
It was direct favorism to Shobika.
And you know...
Please get hold of the volume 3 of the documents by the Deputy President.
Sorry?
You get hold of volume 3.
Counsel, you may assist me.
Volume 3 of our bundle of documents. And as soon as you get it, you go to page 221. Volume 3, page 221, Mr. Witness.
Just a minute.
And as soon as you grab it, you go to paragraph 100.
Which page?
Page 221.
221.
Paragraph 100. Volume 3.
221, just 1 minute.
let me assist you with my bundle because we want to save time. Page 221.
Which
Look
paragraph?
at paragraph 100.
Paragraph 100. Yes, I'm there.
Yes, paragraph 100.
I'm there.
Yes, can you read what the report indicates?
In its report, dated 25th April 2023, Global Fund noted that KEMSA had failed to apply the evaluation criteria consistently to all bidders and that none of the bidders met the minimum requirements.
So what is indicated that none of the bidders met the minimum requirement? Yes. Let's go to page 221, 222.
Now,
22. At paragraph 106.
222.
And again, read it loudly.
Notwithstanding KEMSA's reservations, in a letter dated 4th May 2023, the Acting Director of Procurement recommended termination of the process. The CEO approved, and on 5th May 2023, the termination was communicated.
What was terminated?
The process.
The process of bidding, correct?
Yes.
Why was it terminated?
Now,
paragraph 100, Mr. Witness,
no,
paragraph
Counsel,
100.
Counsel, look.
You know, I am cross-examining you.
I will only deal with my evidence. I will not deal with the evidence of other institutions. The Senate is an independent institution. The ESCC
that we know
conducted its own investigation. Please ask me questions related to the investigation.
Now, after making your statement, please read the reason why the termination was actuated at paragraph 100.
If you want me just to read for the sake of it, but I'm not owning this evidence. I'm only owning the evidence by ESCC.
I didn't ask you to own it.
Witness, the counsel is asking you to read a certain paragraph.
Okay.
Just read it.
Guided.
Yes?
Which paragraph?
I have asked you to read paragraph 106, correct?
Yes.
About the terminations, correct?
Yes.
And I've asked you to state for the assembly the reasons why the terminations is being recommended, correct?
Yes.
And I've told you that that answer, you'll find it at page 221, paragraph 100, correct?
Correct.
And that the bidding was terminated because the bids failed to meet the minimal requirements, correct?
Correct.
And therefore, the cancellation was not as the result of your alleged favorism, correct?
That is not my evidence. My evidence is...
Yes, I know.
...was clear favorism.
Clear favorism.
Yeah.
Look at paragraph 226. Sorry, page 226.
226. I'm there.
Yes. Look at paragraph 136.
I'm there.
Yeah. Read paragraph 136.
In late April 2023, he learned from the Global Fund.
Who is this learning from Global Funds?
Oh, you just took me there straight.
Yeah, look at paragraph 225 so that we can get to know who is learning.
235 or 2?
Yeah, 225.
225.
That is the evidence by one Dr. Andrew Mulwa, acting CEO KEMSA, correct?
Now, 225. 125 if you...
225. Up here.
Which paragraph?
Up here.
Yeah, submissions by Dr. Andrew Mulwa,
yes,
CEO.
So what is he saying now at paragraph 136?
136. In April 2023, he learned from Global Fund pre-award review report that the long-lasting insecticide nets tender was to be cancelled on account of inconsistencies in the bid evaluation.
Yes?
Yes.
So why was it cancelled?
The issue would be who caused the bid.
No, it's not who caused. We are looking at the report. What does it indicate at that paragraph, the issues of the cancellation?
Paragraph 136?
Yes.
On account of inconsistencies.
It speaks to the fact that the bid or the tender was cancelled, correct?
It does, yes.
And it speaks to the reason that it was cancelled on the basis or on the reason of inconsistency, correct?
Correct.
And therefore your testimony that was a result of favorism does not sit well with the evidence contained at paragraph 136 of the bundle, correct?
This, my evidence...
No, I just want you to limit yourself to that paragraph vis-a-vis what you stated. That the reason for the cancellation was the inconsistency, Mr. Witness, yes?
Inconsistencies, yes. But
thank you. Let's go on.
How is the inconsistency?
Let us go to that one. You shall explain in another forum, not here.
Yeah. Continue.
Let's go to paragraph 230, to page 230.
Page 230.
Yes.
Which paragraph?
230.
Which paragraph?
Paragraph G.
G, yes.
Yes?
Yeah.
Can you read it out?
At the evaluation stage, the audit team established that only 2 bidders passed the preliminary evaluation and proceeded to the technical evaluation, that is bidder number 3, Tianjin and Coal International.
Which two companies passed?
As per this one, Tianjin Coal,
yes,
International,
yes,
bidder number 7,
yes,
Premium Evaluation Committee.
It should be.
No, it's.
Look at paragraph 230. It's 231 paragraph.
J, yes.
Yes, read J.
The termination of the tender complies with the Act and Global Fund
was lawful, correct? And it complies with procurement. Yes?
Correct.
246.
246.
Yes. 213.
46.
Paragraph 213.
213, yes.
Yes. What is the report indicating?
The tender at KEMSA, TNT, 2 million nets on .org website. Payment was subsequently done in provided by the ministry.
Eventually procured, correct or not correct?
They were eventually
took the interventions of procure them, correct? And you look.
Yes. Prior to the cancellation between Global Fund team and the immediate State Department of Public Health with regard to the operations, the DNPM noted that this
played a role in the funds to terminate the tender process. Did that have anything to do with, according to the statement of justice? It has nothing to do with the Deputy President. Let us know your issues 71. 271.
Page.
Yes, and read loudly paragraph 24 and 25.
271.
24 and 25.
The committee, that is 24, following the termination of the tender while there was...
Just read it loudly.
The committee observed that following the termination of the tender while there was
no apparent loss of...
lost USD 589.4 approximately 70 million in procurement fees.
The report from the Senate indicates there was no loss of public funds, correct?
Let me read this paragraph again so that we are together.
Proceed.
The committee observed that following the termination of the tender, while there was no apparent loss of public funds,
just put a full stop there. Pause. What has the committee observed?
You don't want me to finish the sentence?
Yes, I'll lead you to that other part.
Okay.
What has the committee observed?
No public funds lost.
No public funds lost. In your investigations, separate investigations that you conducted, did you arrive at the same conclusion? Did you or did you not?
There was no public funds lost.
There was no public funds lost.
Terminated.
Thank you.
Yeah.
So let us look at paragraph 25.
25, yes.
Yes, read it out.
The committee observed that the cancellation of the tender appeared to have been influenced by Global Fund's apparent effort to exert significant control over the procurement process from the beginning to the end.
Thank you. What occasioned the cancellation?
The cancellation of the tender appeared to have been influenced by the Global Fund's apparent effort to exert significant control over the procurement process.
Is there any evidence indicating that the Deputy President was involved in that process?
No.
Was his companies involved?
No.
Was his family involved?
No.
Any evidence that you have before this assembly to that respect?
The evidence I have.
No. Any evidence that any of them were involved?
On this report? Or my evidence?
This report?
On this report, no, but my evidence is.
Let us go to the next paragraph, yeah? This concluded that Global Funds teams based in Geneva, Switzerland, making multiple trips to Nairobi, Kenya, at least 3 times during the relevant period, raising concerns about the autonomy and the ability of the local government. Just read it out.
That is paragraph 25.
Yes, the same paragraph.
Okay. The committee observed that cancellation of the tender appeared to have been influenced by Global Fund's apparent effort to exert significant control over the procurement process from the beginning to the end. This included Global Fund team based in Geneva, Switzerland, making multiple trips to Nairobi, Kenya, at least 3 times during the relevant period, raising concerns about the autonomy and the ability of the local government agencies.
The autonomy of the organization, correct? Let us look at paragraph 222 again. Sorry, page 222. Page 222, Mr. Witness.
222.
And while you get there, you look at paragraph 107. Page 222.
Paragraph
107. Would you kindly read it out?
107. It is further her testimony that, I don't know whose testimony this is.
Yeah, that is a testimony of the submissions of Terry Ramathani, immediate CEO.
Okay.
Yes, you find that at page 219. Yeah, but now I'm interested in paragraph 107.
It was further her testimony that the authority had struggled to maintain its autonomy.
The authority has struggled to maintain its autonomy, yes.
Owing to the undue influence.
Owing to undue interference.
Interference by the Cabinet Secretary.
From the Cabinet Secretary for Health, yes. Post. Who was the Cabinet Secretary for Health at the time in issue?
Oh, we can check that one.
Yeah, who was? This regime has only had two Cabinet Secretaries.
Let me just confirm from my records here. Because she did a letter to us, so.
Council Jiro.
The name is
just hold on, witness.
This is Wafula.
Hold on, Mr. Abdi.
Yes, sir.
Council Jiro.
Yes, Mr. Speaker.
I thought when you're cross-examining a witness, you cross-examine on the evidence they've given. You totally abandoned his evidence.
Those are not the rule of cross-examination, Mr. Speaker, sir. I respectfully beg to differ.
The reason why the witness has difficulties.
He doesn't have difficulties in the speaker.
No, he has.
No, I am asking him to read. Okay, I will be guided.
Proceed, if that's your line of argument, proceed.
Thank you for giving me the latitude. Who was the Cabinet Secretary at the time the bid was being cancelled?
She's Nakumicha
Wafula. Has the Senate found that what occasioned all these cancellations of these tenders was the loss of the autonomy of KEMSA?
I would want to confine myself to my evidence.
I know. At this time,
I would want to talk about the evidence.
Okay, then read that paragraph. Just read for me.
Which paragraph?
Paragraph 107. And I want to finish up with you.
Okay. Paragraph 107. It was further her testimony that the authority had struggled to maintain its autonomy owing to the undue interference from the Cabinet Secretary for Health. For instance, she stated that on 22nd March 2023, she received a note from the CS asking her to assist a certain Mr. Ken Ogola.
She received a note from the CS asking the CEO to assist one Ken Ogola, correct?
As per this statement, yes.
Have you seen any company associated with the Deputy President being accused of these interferences?
No.
Let's go to your bundle as I finish up, volume 8A. Any evidence from volume 8A that you've brought that links?
That?
that links the Deputy President's company to the cancellation of the tender?
Yes.
Look at your paragraph, look at your letter dated 23rd September. Your letter dated 23rd September, and look at the recommendations.
Yes.
What are you recommending?
We are recommending for admin action against the KEMSA officials and the Ministry of Health officials. There is a pending issue.
It's okay. I want you to limit yourself to what I am asking in that respect.
Yes.
You are recommending administrative action to KEMSA officials.
Yes.
Correct?
Correct. But the file is
in that particular paragraph, any recommendation for the prosecution of the company in issue? In that particular paragraph?
The file is still open.
It's okay.
As per these recommendations,
you brought the documents here. We are dealing with what you have brought, not what you have in the office.
Yes.
Any recommendation in respect of that company?
No.
Thank you. Let us go to a letter dated 21st August. Correct?
Of my bundles?
Of your bundles.
By who?
The EACC bundles, the one that you're just looking at. Okay. Don't leave volume 8A. You can see the letter dated 21st August, correct?
Just a minute, I get the letter. 21st August, yes.
Can you see the recommendation at page 7?
Yes.
What are you recommending?
We are recommending for the investigation established that the Chief Executive Officer at KEMSA, Terry Ramadhani, failed to ensure complies with the procurement processes and the law, contrary to Section 44 of the PPDA Act.
That Ramadhani was in breach of the law, correct?
Correct.
A person who is in breach of the law, what happens to him or her?
There are many ways of dealing with that. We can charge.
The law sanctions that act, correct?
Exactly.
Do you know what sanction was given to Terry?
I wouldn't know, but
Do you know that she is now currently the ambassador to New Delhi?
That was not our expectation. We
I know.
Administrative action taken against the lady.
So, did any person, either the Chief Executive Officer, report to you that he has received any intimidation, harassment, bullying from the office of the Deputy President?
No.
Yeah?
No.
Did you receive any complaint?
Not to EACC.
Did you receive any complaint?
No.
Thank you. Now, Mr. Witness, finally, where do you place your evidence in these proceedings?
In these proceedings, I place my evidence on the conflict of interest bit.
Conflict of interest.
Which I said, personal interest.
It's okay, that you said, and I understand the law.
Allow me to finish, please.
So show me in the notice of motion, I put it to you, that in the notice of motion, there is no charge as against the Deputy President for conflict of interest. Does that surprise you, that there is no such a charge?
It doesn't.
Thank you. No further questions.
Counsel for the National Assembly, you may examine the books.
Now, Mr. Witness, only one more question. Between your statement that you have made and the Senate's report, which one do you want us to rely on?
Which
one? There are only two options. It's either your report or the report by the Senate. Don't give me an explanation.
I can stand by my report.
So we disregard the report by the Senate, correct?
I didn't tell you that. I didn't say that.
We disregard the reports by the Senate. Is that the contempt that you have for this House?
I can only stand by my evidence, which I can prove in any forum.
Has that report by the Senate indicated any investigations on the ground of favorism, conflict of interest, and gifts?
No, I haven't gone through the report, so I wouldn't want to comment.
Thank you.
Are you done?
Yes, Mr. Speaker, sir, but you're addressing me.
Are you done?
Yes, I am done.
Take your seat.
I'm also obliged.
Mr. Speaker, I believe I had around 4 minutes, 5 minutes.
Go to Counsel. Now, I'm afraid, Counsel, your time is up. However, you have 2 hours to cross-examine the Deputy President. That's where you can borrow from.
Mr. Speaker, I wish to borrow 10 minutes in respect of this witness.
Laura, proceed.
Mr. Mahmoud, do you still have the bundle of volume 3?
Yes.
Do you still have volume 3 from the... It's a bigger volume than that.
Yeah?
It's a bigger volume.
Oh.
Let me take you to page 236 of that report. Of that bundle, sorry.
$236.
236.
Yes, I'm there.
You're there.
Yes.
Go to paragraph 188 and inform the Senate
I'm there.
what the Senate stated in that report, in that paragraph.
So 188, at the financial evaluation, the evaluation committee, the following bidders, the evaluation committee, I think there's a word missing. The following bidders for award. Item 001, that is mosquito nets treated, rectangular polythene. Number 1 is Shobika Impex Private Limited. Piece.
So bidder number 2, Shobika Impex Private Limited, was recommended for award at a price of USD 9 million.
Correct.
So there was indeed a recommendation by the evaluation committee for an award to Shobika Impex.
Correct.
And it is contained in the report of the Senate.
Correct.
Confirm also that what you've been taken through by my learned friend are the various testimonies of the witnesses who appeared before the Senate. And those testimonies ran from page 202 all the way to page 265. Is that correct?
202, yes. That's correct.
So what council has done is to give you the various contestations by the witnesses who came before the Senate. Is that correct?
Correct.
What is important is the recommendations and the observations of the Senate, which is contained in pages 266 to 274.
Correct.
Is that correct?
Correct.
And allow me to just highlight 3 of the observations which were taken out by the Senate. Look at page 267. Page 267, under the rubric.
Yes. Which
in
paragraph?
regards to the tender specifications.
Which paragraph?
Page 267, title B.
Title B, in regard to the tender specifications.
The Senate picked out the tender specifications as an issue, which emerged, correct? That the extension appeared solicited and mischievous, and they then go ahead to give reasons.
Yes.
6 reasons, actually.
Sure.
Hyphenated. And then they also pick out under D the manner in which KEMSA evaluated the tender. Is that correct?
Correct.
So this report of the Senate rhymes with your observations in all material respects. Is that not so?
Correct.
At paragraph E, the Senate then discusses the process which led to cancellation. It's titled cancellation of the tender. Is that correct?
Correct.
And they say that though there was no loss of funds, KEMSA lost 70 million shillings.
Yes.
In procurement fees.
Yeah, paragraph 24. Yes.
So in all material respects, this report rhymes with the report of EACC.
That is correct.
And there is no reason for you to disown it. You've also been told that conflict of interest is not an issue which has been raised by the mover of the motion.
Correct.
To the best of your knowledge, does the Ethics and Anti-Corruption Act, Anti-Corruption and Economic Crimes Act, have a clause on conflict of interest and makes it an offense?
Yeah, it does. The Leadership and Integrity Act also does. Yeah.
I will identify to the Senate during my submissions the relevant section which is contained in the motion. Thank you, Mr. Mahmoud. And we wish to close with this witness, Mr. Speaker, sir.
Thank you. We will now move to allow honorable senators to ask questions or seek clarifications. Starting with the senator from Nairobi City County. Senator Eddy.
Mr. Speaker, I've got two quick clarification questions. One from the witness.
With this witness, Mr. Speaker, sir.
Thank you. We will now move to allow honorable senators to ask questions or seek clarifications. Starting with the senator for Nairobi City County. Senator Eddy.
Mr. Speaker, I've got two quick clarification questions. One from the witness, and then one from the counsel who cross-examined the witness. Mr. Abdi, you have indicated to this Senate that eventually, of all the 17 companies that did bid for this tender, all of them eventually got all their bid bonds and documents back. However, the witness that appeared before us, called Mr. Mulo, indicated that on the 11th of July 2023, he received a phone call from the Deputy President to be able to come and collect the bid bond for Shobika, specifically from EACC. I want to know, when did the other 16 companies get their bid bonds from EACC? Did they get it at the same date that the former witness indicated that he waited for 5 hours from EACC, or did they get them from EACC at a variable date? Then lastly, Mr. Speaker, the counsel for the Deputy President has heavily relied on the Senate report. And if you look at page 218 all the way to page 230, it is submissions to Senate by different individuals. Counsel, do submissions itemized by individuals who appeared before Senate in your best understanding amount to Senate's finding and resolutions in your best understanding? And what do you make of page 275 of Senate recommendations and not findings? Because you did indicate to this House that those were Senate findings. Are they findings, or are they submissions of individuals to the Senate of Kenya? Thank you, Mr. Speaker.
Senator Mngatana.
Asante sana Bwana Spika. Swali langu kwa mshahidi. Umeelezea bunge la Senate ya kwamba wafanyikazi wa serikali hawakubaliwi kuchukua pesa, lakini wafanyikazi wa serikali wanakubaliwa kuchukua zawadi aina ingine. Uko na orodha ya yote ya hizo ng'ombe za maziwa ambazo zilipatikana, ambazo anasema Aliziorodhesha? Hiyo ndio swali yangu kwako. Asante.
Senator Jesang Alan.
Thank you, Mr. Speaker. The Council of His Excellency the Deputy President, to tell the House why was it the Deputy President calling the CEO of KEMSA asking for a release of the bid bond and not the CEO of Crystal Company, yet he's not an employee or a director of the said company. Number two, Mr. Speaker, number two, I equally want to ask the Council of the Deputy President to enlighten me and prove to this House that on how the call by the Deputy President to the CEO of KEMSA pertaining a bid bond that was in process of a contract, not a conflict of interest. And lastly, Mr. Speaker, I'd also like to ask the Council if the Deputy President knows that he's not a regional leader, but a national leader. Thank you, Mr. Speaker.
Senator Fatuma Dulo.
Thank you, Mr. Speaker. My question is to the DP's counsel. Now, I saw you trying to cross-examine the witness before us on a report of the Senate, which I believe he has not interacted with. And again, the motion that was before the House and also the National Assembly. What are you trying to drive out of that? I thank you.
Senator Joyce Korir.
Yeah, thank you very much, Honorable Speaker. My question is, I wanted to know what informed the extension of time, the change of dates from the extension of time from during the procurement process. Thank you.
Senator Karungo.
Thank you very much, Mr. Speaker. My question to Mr. Abdi. You receive a letter from the Health Ministry on 11th May 2023. Then in your wisdom, you replied 16 months later, when the CS has even left the office. My question, and that is 5 months after the Senate looks into the issue and comes with a report. Are you part of the conspiracy? Don't answer me, answer your children.
Senator Sigei.
Honorable Speaker, the question I intended to ask has already been asked by my colleague, Senator Mogatana, so I do not need to waste the time.
Senator Kibwana. And honorable senators, you know, when you're given an opportunity to seek clarification or ask a question, it is not a moment to get a TikTok clip. Please, this is a very serious matter. Proceed. Let us not embarrass this House. Proceed, Senator Hamida.
Thank you, Mr. Speaker. Mr. Speaker, to Mr. Abdi, I just wanted a clarification whether EACC, when EACC conducts their investigation, are they guided by other investigations? Because through the cross-examination, I think it was vis-a-vis the parliament investigation. So I think these are two different investigations. So I wanted that clarification, whether you are guided by Parliament, because the Parliament are not experts. That's why we always bring in or loop in EACC to assist us with the investigation. Number two, would you call it a bribe if a gift is not declared, or gifts in a public office? Would you call it a bribe? Just the last one to the council. How do you cross-examine what someone came and said, but not exactly specific findings of the Senate? Because I found it a bit contradicting. Because the resolutions of the Senate is based on committees' observation and recommendations, but not investigations. Thank you.
Senator Kathuri.
Thank you, Honorable Speaker. Honorable Speaker, mine is not to the council or to the witness, but to the remarks which has been given out here by Senator Karungo Dhango. Mr. Speaker, I don't know whether you heard what he said, and I do not associate myself as a senator, honorable senator, with those remarks to a witness appearing before the Senate, that please don't answer me, answer your children. Mr. Speaker, that should be expunged from the records of the Senate and from the answer, Honorable Speaker.
Order, honorable senators. Senator Karungo, that is unparliamentary and totally out of order. Proceed to retract that statement, failure to which the chair will rule.
Mr. Speaker, as I withdraw, this session is viewed by everybody. At home, our children too. Mr.
Senator
Speaker.
Karungo, I never give you an opportunity to make a speech. Retract or you allow me to make a ruling.
Okay, Mr. Speaker, I retract.
Take your seat.
I withdraw, and please answer me.
Take your seat, Senator Karungo, please. Senator Keroche Tabitha.
Thank you. Thank you, Mr. Speaker, sir, for giving me this opportunity. And as a mother, I think I've also felt I'm hurt with Senator Karungo. But because it has been ruled, thank you. We should never, ever. I know we had a meeting, closed our meeting before we started this. And we all agreed we are going to behave. Thank you, thank you, thank you.
Proceed to seek
so,
clarification.
mine is to the Abdi. My question is to the Abdi on whatever you are trying to do on the procurement irregularities. But my question is, are you doing to the others, because there are a lot of complaints on the procurement departments in all the ministries. So I hope this continues to everywhere. Thank you.
Senator Richard Onyonka.
Thank you, Mr. Speaker. I wanted to ask Mr. Abdi this question. In your observation, maybe in just a paragraph, what do you interpret happened about this tender from its inception, in terms of the procurement, in terms of the management of the exercise and the conclusion, as an officer whose responsibility is actually to investigate if there was any breakage of the law, and if necessary, make recommendations to the DPP. What conclusion did you reach when you were analyzing this matter? Thank you, Mr. Speaker.
Senator Karen Nyamu.
Thank you, Mr. Speaker. Dr. Mulwa, before this House, implicated the Deputy President in a scandal of the 3.7 billion KEMSA deal. In your own investigation, can you corroborate what Dr. Mulwa has claimed before this House? Thank you.
Senator Tom Ojenda.
Thank you, Speaker. Speaker, my question is different. I want to ask the previous, the advocate who spoke or presented the Kenya Kwanza agreement, my learned friend, to clarify a few issues. Mr. Yes, Council, can you clarify from the agreement, the Kenya Kwanza agreement, whether there are any shares for the following counties? Please note this. This is important. Kisumu County, Siaya County, Migori County, Homa Bay County, Kitui County, Mombasa County, Vihiga County, Mandera County, Marsabit County, Trans Nzoia, West Pokot, Lamu, and Nairobi County. I just want to know whether, and this is important because the legal crinkum crankum, the twists and turns in this is that you will then interpret, Council, whether the agreement violates Article 210(2)(b) of the Constitution, inclusivity, diversity, discrimination, and the obligation of the President under Article 131. Lastly, Council, please just tell us whether, in your view, the relationship between the Deputy President and the President, because you played the two clips under Kenya Kwanza, has broken down irretrievably. That will help us. Thank you.
Senator Essie Okanyure.
Thank you, Mr. Speaker. I would wish to seek more information from Mr. Abdi on was it in order for the bid bond document to be released while there was an ongoing investigation? And secondly, did EACC clear Madam Terry Ramadan as the ambassador? Thank you.
Senator Enoch Wambua.
Thank you, Mr. Speaker. Mr. Speaker, a few things to clarify from EACC. One, did you find it necessary to record a statement from Crystal and Shobika in that probe? Because they had been mentioned. Were they entities of interest in the investigation? Secondly, has Shobika ever done any business with KEMSA or with Global Fund before the case on record? In your own investigations, did you find that? In your letter, I see you have recommended administrative action against the CEO, the acting director of procurement, and 2 procurement officers. I see no recommendation of any action, not necessarily by KEMSA, against Crystal or against Shobika. And I think that's in line with your own recommendation that in this case on record, there was no public funds lost, and eventually the bid was returned. So in your own investigation, what is at issue here? I thank you.
Senator Mofaya.
I don't know whether this. Honorable Speaker, I want to know from the witness from the EACC. I've listened to his evidence, and I would want to know, on behalf of the whole House, whether the contract for mosquito nets, which was drawn out of interference, because I have captured those confessions from him. So my question is, Honorable Speaker, can he connect the company associated with the DP with the withdrawal of that contract? Number two, Honorable Speaker, I have also listened to Mr. Murwa, Dr. Murwa. One would want to know, is it normal for ordinary CEO to come and camp in your office for 5 hours?
Senator Muma.
Thank you, Honorable Speaker. My question to the witness is that we've been told by Dr. Mulwa that the people of Kenya lost money, they lost time, they lost the number of nets they were going to get, and services to people. Now, does EACC end at just saying you recommend administrative action? Now, who takes responsibility for the loss of all of that the people of Kenya did? And what responsibility is taken in respect of tinkering with the procurement in order to give it to the wrong person for it to be found not to have been correct? Honorable Speaker, one more question to Council. Now that Professor Ojenda has asked, I want to take opportunity to ask Council Macharia, you referred to the Political Parties Act, Schedule 3, as the instrument with which you allege that the shareholding, in your view, that was being spoken about is contained in the coalition government of Kenya Kwanza. Can you give us the exact provisions of Schedule 3 of the Political Parties Act that says that shareholding can be done on development projects in Kenya?
Senator Mugo. Senator Mugo.
Thank you very much, Mr. Speaker. I have a question for the Excellency Deputy President's Counsel as to whether the Deputy President, in his own conscience, realized that this shareholding narrative is really going negative, and what did he do about it? Or he just went all the way up to where things are now without he himself realizing that it is going the wrong way?
Senator Jonyut.
Thank you, Mr. Speaker. Very briefly, just want to ask the witness, Mr. Abdi. He has stated that as per their investigation, EACC, that the closing date was moved for this tender, particular tender, was moved from the 23rd of February 2023 to 10th of March in order for the process to favor Shobika, or whose local agent was Christo. Can you clarify, Mr. Abdi, whether this extension of the tender period was due to the late delivery of bid bond, because you said that the tender was also attached to a bid bond that was late? Was the reason the late delivery of the bid bond, or the specifications of the long-lasting net from synergist peronil, something like that, but side to pyrethrin? Exactly what was the reason? Was it late delivery of bid bond or the specification? Number two, Mr. Abdi, you have indicated that the authority did not prefer any charges against the officers of KEMSA and the PS herself. Is that the right thing that EACC was supposed to do, or it should have preferred charges against these errant, in quotes, officers? And finally, why were the companies that were eventually given the tender or awarded the tender by Global FAD, why had they initially been disqualified by KEMSA? Thank you, Mr. Speaker.
Senator Lelegwe.
Thank you, Mr. Speaker, sir. I would like to seek clarifications from the Advocate of the National Assembly in reference to Ground 11, which pertains to gross misconduct bullying. You have alleged that that His Excellency the Deputy President exerted undue pressure on officials of Kenya Medical Supplies Agency in order to secure a tender for supply of mosquito nets to Crystal Limited, a company purportedly associated with him. Now, upon reviewing the documentation provided, I have noted that 17 companies submitted bids for this tender, yet it was ultimately not awarded to any of them. Given these findings, may I inquire from you whether it will be correct to assert that this particular ground lacks sufficient substantiation, considering that no award was made in respect to the tender in question? Thank you, Mr. Speaker.
Senator Chimera.
Thank you, Mr. Speaker. Three quick issues to the witness. I wish to refer the witness to page 17 of his own document. And I know he is a very serious investigator, Speaker, but the document on page 17, dated 16th July 2014, as tabled here, is so naked and so casual, and it's purportedly coming from the Pest Control and Products Board. There is no letterhead as to confirm the authenticity of this document, Mr. Speaker. I don't know how the witness intends to allow the Senate to authenticate this document. Secondly, Mr. Speaker, is on his allegation on the conflict of interest on the part of the DP insofar as this tender is concerned. Is it your contention that the mere fact Crystal Kenya Limited is the local agent of one of the bidders in this tender, then that will suffice to be conflict of interest enough on the part of the DP, because the owner of that company assigns to the DP? And lastly, Mr. Speaker, the witness has been cross-examined by my learned colleague, counsel for the DP, largely on contents of the Senate Standing Committee on Health report, as opposed to his own documents. Do you want it to go on record that you want to rely on that report as your evidence in chief, or should the Senate rely on your documents as tabled under volume 8A of your own documents? Thank you, Mr. Speaker.
Senator Shakil Abdallah.
Thank you, Mr. Speaker. My question is to Mr. Abdi. How many more charges against the deputy are before the EACC apart from the KEMSA? Thank you.
Senator Aaron Cheriot.
Mr. Speaker, just a quick question to Abdi of EACC. This issue of the bid bond, Mr. Speaker, listening to the former acting CEO, there's something curious about it which I want Abdi to either confirm or help us understand. That there was something peculiar. You know, Mr. Speaker, when you hear about pagination, if you know anything about tenders, you know for a fact that if there's an issue on pagination, either it's not just an issue of forgetting to page or number the pages, Mr. Speaker, but that document may either have been added later on after the tendering process was concluded, or, Mr. Speaker, it was defective. What was the real issue according to their investigation, with regards to the bid bond that was submitted by this specific company? Secondly, Mr. Speaker, what in his assessment will he say is a reading of the donor community when you have such important programs interfered with, aside that the donor communities themselves end up cancelling such important programs, and what are they recommending? Finally, Mr. Speaker, is to Advocate Ndegwa Njiru. He asked the witness earlier which of the report would he, that this House believes, that of the Senate or of the EACC. I'd wish to pose the same question to him. I thank you.
Senator Murango.
Asante sana mstahiki Spika. Swali langu litaenda kwa Bwana Abdi. Kwa sababu anayehukumiwa hapa ni naibu wa rais, tungetaka kujua kwamba kwa sababu mlifanya uchunguzi, ni kesi ngapi ama kuna kesi yote ambayo EACC imepeleka mahakamani ili naibu wa rais aweze kuhukumiwa? Jambo la pili, wakati kulikuwa naibu wa rais alikuwa anachunguzwa katika bunge la kitaifa, kuna ushahidi wote ambao wewe uliwasilisha katika bunge la kitaifa? Na kama hukuwasilisha, kwa nini umeamua kuwasilisha tu nyumba la seneti na sio bunge la kitaifa? Na ya mwisho, katika zabuni ambayo ilikuwa ni ya viandarua vya mbu ambayo naibu wa rais anasemekana alihusika nayo, tungetaka tujue ya kwamba kwa sababu ile zabuni ilikuwa imeghairiwa na KEMSA, na kwa hivyo dhamana ya zabuni ambayo ni bid bond kwa kimombo ilikuwa inafaa kurudishwa, tungetaka tujue kama hiyo dhamana ya zabuni ilirudishwa na iliitishwa, ingekuwa inasaidia naibu wa rais na nini, ama kungekuwa na manufaa gani ya kurudisha dhamana ya zabuni kama ulivyorudisha zingine 17? Hiyo ndio tungetaka kujua. Asante sana Mr. Speaker.
Senator Mogene.
Yes, Bwana Abdi, on this issue of irregular procurement of malaria nets with KEMSA, you know, you have given us documents that basically point to some recommendation for administrative action to be taken against a number of officers. But you know, what is of our concern today is companies associated with the DP. Can you tell us anything that you found irregular around the subject matter that concerns us this afternoon? That is the companies associated with the deputy president, Bwana Acting Deputy CEO. Thank you.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, we are lucky that the EACC is here with us. And there are serious allegations that have been raised that require investigations. Could the CEO, the deputy, confirm if indeed there are investigations taking place on your own motion on the following issues? One, on the activities of this intricate web of companies by the Deputy President, on the issue of the disinheritance of the orphans and wife of his late brother, His Excellency Nderitu Gachagua. 3, on the alleged insubordination of the President. And finally, if there are investigations on the role that His Excellency the Deputy President played in the infamous Gen Z uprising that occurred in June. Thank you, Mr. Speaker.
Senator Cherake.
Thank you, Mr. Speaker. 3 quick questions. Like an eye of a military marksman. 1, I need clarification on Section 14 on cultural gifts. Especially some of us, when in our community, when we respect you, we give you cows. Does it qualify within the meaning of Section 14 Number two, I've seen administration action against KEMSA officials and ministry officials and KEMSA. Since you recommended administrative action, have you gotten feedback from KEMSA? And number two, did you recommend any action against companies? And finally, are there any active investigations by EACC against the person of Rigathi Gachagua or against the Deputy President of the Republic of Kenya? I thank you, Mr. Speaker.
Senator Mutinda Tabitha.
Thank you, Mr. Speaker. Mine is to the Council for the National Assembly. You have presented before this House two witnesses, Mr. Abdi and the previous one, Dr. Mulwa. Dr. Mulwa before this House stated that there was no loss in regards to this procurement process. Mr. Abdi's report indicates very clearly that there was no loss of public funds. Would you tell this House, between your two witnesses, who is telling the truth, who is not telling us the truth? Secondly, EACC, as far as Crystal Limited is concerned, have you established any evidence that shows that the Deputy President of the Republic of Kenya benefits directly or indirectly from this particular company? And lastly, my colleague asked about the former CEO, Ramadan. You had recommended action to be taken. In your report also, you indicate that she violated Article 10. Does it end there, Mr. Abdi? Because she's now working in a different capacity. What action are you supposed to take, or do you intend to take? Do you do recommendations and not adhere to them? What's the conclusion as far as this kind of reports are concerned from your office? Mr. Speaker, I ask this because Kenyans sometimes say that the Senate does not do oversight. We do not really take action, but we recommend. And this is now the situation that we find ourselves in, that your recommendations that
Senator Montet Batuli.
Thank you, Mr. Speaker. I would wish to ask the CEO, what did the EAC, what is EAC planning to, is EAC planning to press charges on any of these companies that you say that you've investigated and found that they had interfered either through their agents with this particular tender? And if not, are you planning to do it, and when are you planning to do it?
Senator Veronica.
Just a quick clarification. Can you confirm or clarify whether these investigations have been closed by EACC in respect of this procurement at KEMSA, and whether there are any further persons of interest whom you have sanctioned or issued any notices of prosecution or anything of that sort beyond the letters that are attached to the affidavit? And in the course of your investigation, did you bother to find out what was the content of the phone calls that the acting CEO of KEMSA said was used to intimidate or cause pressure to him? Did you investigate the contents of that phone call?
Witness, you may now proceed to respond. Proceed, witness, to respond. Proceed to respond, witness. Order, honorable senators. If you have noticed, Honorable Seki, Honorable Seki, Honorable Seki, this hearing will terminate beyond midnight today. Let the witness respond to the queries that have been sought. Thereafter, we'll go for another round. Is there any problem? Honorable Seki, order, honorable senators. If you have noticed, Honorable Seki, Honorable Seki, unless you apologize, I'm going to throw you out of the chamber. You cannot say the chair is biased. If you've noticed, we've been going on lots. One lot, the witness answers, then I go to the queries that are. Honorable Seki, unless is there any problem? Honorable Seki, you're out of order. You're out of order. And I'm asking you to leave the chamber immediately. You cannot. You cannot direct the chair on what to do. Honorable Seki, unless you apologize, I'm going to throw you out of the chamber. You cannot say the chair is biased. If you've noticed, we've been going on lots. I'm going to rule you out. One lot, and I'm going to throw you out.
You know, I've never stood on this.
Just apologize. We need
Honorable Seki, you apologize or I throw you out?
You know, you as a speaker, I have come to a desk. I have a representation of Kajiado people. I have a right to speak in this assembly.
Just
you should
like
not
another senator.
Seems to be biased.
Honorable Seki, you either apologize or I'm going to rule you out of order and I'm going to throw you out.
You know, I've never stood on this.
Just apologize. We need
Order, honorable senators, order.
Let me just apologize.
Of course, but that's how. Honorable Seki, I have not heard the apology. Honorable Seki, you either proceed to apologize to the chair or you exit the chamber. Proceed. The floor is yours, Honorable Seki.
I apologize.
Take your seat. Now, Honorable Seki, Honorable Chute, and Honorable Omtata, you're totally out of order, pursuant to Standing Order 121, and I'm cautioning you. The first caution for the day. Honorable Chute, every senator here is elected to represent their people. If you notice from yesterday, we are going with lots. There is no senator who is more important than the other. Proceed, witness.
Thank you, Honorable Speaker. I may not have captured the exact names of the Honorable Senators, but I will deal with. Shobika was the special company that we were looking at, and that was the reason why that particular one was identified, because the bid document actually had challenges, as I had indicated in my evidence in chief. Then we come to Honorable Mungatana, issues of gifts and the cows. Now, as I had indicated, gifts that are of value of more than 20,000 shillings are supposed to be handed in and declared by all public officers, including state officers. For this specific matter, we have not investigated as to the existence of the material, cows that are in this particular issue. But if indeed cows have been donated to any public officer, those donations are supposed to be donated to the state. And the officer within 48 hours is supposed to hand over that donation to the institution that employs him. So that is my take on that. Then we had the issue of extension of time for the bid bond. Now, as I had indicated previously, the closing date for this particular tender was supposed to be on 23rd February. Bid bonds are supposed to be attached, or they're supposed to be part of the bid document, the tender document. In this particular case, the bid bond was hand-delivered to the CEO in her office when the tender documents were already inserted in the respective tender boxes. So for that reason, extension had to be found in order to have that document be part of the tender document of that particular company, which is Shobika. So that led to the extension in February. Bid bonds are supposed to be attached, or they're supposed to be part of the bid document, the tender document. In this particular case, the bid bond was hand-delivered to the CEO in her office when the tender documents were already inserted in the respective tender boxes. So for that reason, extension had to be found in order to have that document be part of the tender document of that particular company, which is Shobika. So that led to the extension, and that was instigated by the permanent secretary, who did a letter, which is in our documents, directing the CEO of KEMSA to extend the date of closure of the tender from 23rd February to 10th March. Now, that is the issue which made the bid bond, the date of extension to be extended, the date of closure to be extended. Now, let me come to investigations by various bodies created by the Constitution. Now, investigations will either be in terms of course, each institution has its own mandate as far as the Constitution or the legislation or the statute that created it is concerned. Now, when it comes to criminal investigation, and specifically issues to do with leadership and integrity, issues to do with corruption, that responsibility lies with the Ethics and Anti-Corruption Commission. Now, other institutions, other constitutional bodies can do their own investigation, but they will if, for example, they are recommending for criminal charges, those recommendations have to be made to the respective institution that is mandated to charge people or to investigate criminal cases, like the DCI or the EACC. So it depends on the mandate of the institution and what is the focus of that particular investigation. But for example, if it is the PPDA, the Public Procurement and Disposal Authority, they do not have powers to charge people in court, or rather to recommend to the DPP to have people charged in court. What do? They have to do a recommendation to either the DCI or to the EACC to investigate the criminality of that particular issue. So I just want to indicate that it depends on the institution and the mandate of that institution. But when it comes to criminal investigations, there are specific institutions that are mandated to conduct criminal investigations. Issues to do with the declaration of gifts, I think that one I addressed in my earlier submission. that gifts that are more than 20,000 are declarable, and they have to be entered in the registers. And after the end of every financial year, the institution has to actually declare to the ESCC of the existence of that gift. Now, the issue of what was our finding or our conclusion when you look at the whole matter and our perception, or rather, what would be our conclusion that we reached. Now, when you look at this particular tender, first, it is an international tender that was floated as an open tender to international companies. Companies bidded, but there is a specific company that has a local agent here, which is Shobika, that did not conform to certain procurement requirements as per the tender document. Because when tenders are floated, that tender has got specific instructions or directions to the people who are bidding. If, for example, you are supposed to do if you are supposed to do pagination, it has to be indicated there. If you have to do, for example, in ink, it has to be there. So anything that goes outside what was provided for in the tender document is actually considered as irregular, and of course the disqualification should apply. So this one, it was a tender that was badly handled, and I wouldn't want to indicate why it was handled that way, but from the look of it, there must have been some pressure somewhere. That is my own view as an investigator, because when you see procurement officers deliberately going out of the requirements, because they know the law, there are only two conclusions that you can make. One, they were bribed. Two, there was an influence that was coming from other quarters. Mainly those are the two reasons from our experience. So that is my conclusion. I wouldn't want to delve into the conclusion of Dr. Mulwa, because he gave evidence before this House, Honorable House, and his evidence is there. Now, the issue of Terry Ramadan and her status, I think ours was, and whether we actually received feedback. As seen in our documents, we did a letter to on Terry Ramadan. Let me refer to the documents. We did to the chairman, the chairperson of the board of directors of KEMSA, and we gave him the reasons why we think, or it was our view, that action should be taken, disciplinary action should be taken against this particular officer. As to why she's still in the public service, I wouldn't want to go there, because our responsibility, when it comes to administrative action, we tell the institution to take the disciplinary action.
Order, Senator Newton.
We do not have the powers
Senator
to compel,
Fernandez, take your seat.
For example, the PS, sorry.
Proceed, Abdi.
Thank you.
Mr. Abdi.
So we do not have the powers to compel the chairperson we don't have the compellence powers as far as administrative action is concerned. So I want to leave that for the honorable members to decide what to do with that. So I move on. Then the issue of reading of the donor community and what our view is. You know, if you may allow me, Honorable Speaker and the members, the medical, or rather the health sector, has faced serious challenges of corruption throughout this period. Throughout the period that I remember working at the ESCC, it is an area where a lot of donors are actually almost giving up in supporting our programs. And that has a serious repercussion. Because first, let's understand.
Mheshimiwa Speaker, in the past, with tremendous respect, with all the other witnesses, you have been indicating how much time they have to respond. 5 minutes, 10 minutes, and my good friend here, the witness, you did not indicate how much time this honorable House is giving him to respond.
Thank you so much, Senior Counsel. That was courtesy of my good friend, Senator Seki. Now, witness, ordinarily we've been given 10 minutes to respond to clarifications sought and questions. So far, you have done 4 minutes and 13 seconds. You have 5 minutes and 47 seconds to conclude.
Okay. Thank you, Honorable Speaker. So that one I've dealt with. So the issue was that was also raised is which report do we stand by? As the SEC, we did an investigation and we submitted our report, the findings of the report to this committee, to this Honorable House, and that is the report we will always stand by and defend. The other issue that was raised was whether we had any case that we have investigated against the DPP and whether we have proposed charges or anything like that. That is, we have not investigated the Deputy President, His Excellency Rigathi Gachagua. We have not investigated him for any criminal matter in the past. That is our position. Now, there was also the National Assembly hearing. Why we did not attend the National Assembly hearing and now we are attending the Senate. We were not invited to the first hearing. Yesterday, I was served with a summons of this House, and we are simply responding to that summons. As to why we were not invited in the other one, that I don't know, and we only responded to the summons that were issued. So then, Senator Omugeni, the companies associated with the DP, we've not investigated any company that is associated with the Deputy President so far, and that is our position. Then, Honorable Senator for Kakamega County, activities that are intricate web of suspected to be corruption. On all the items, Honorable Senator, that you have told us whether we have investigated, I think there are 5. We have not, because a report has not been made to us, and it is we should not only wait for a report. We also have the powers to investigate on our own motion, but it is only after we analyze the reports as to whether they fit in within our mandate. Like, for example, if you deal with issues of inheritance, unless there's a criminal aspect on the inheritance bit, inheritance usually will be handled as a civil matter. And issues to do with intimidation, if the CEO of KEMSA had reported to us that he was actually intimidated by a state officer, we would go into it. Of course, you understand, all of us understand how difficult it would be to open an investigation of that, that magnitude. But no complaint has been made to us. On the Gen Z uprising, also, we have no report. We know it happened, but as to the corruption bit of it, we do not have facts.
2 minutes to go.
Okay, thank you. So, gifts, I think I mentioned, I talked about it. I talked about them very clearly. Issues to do with whether we want to charge, we want to press charges against companies associated with the DP. We have not investigated. We can only recommend charges after investigation to the Director of Public Prosecution. That is our mandate. And the other one, of course, is intimidation by the CEO of KEMSA. I think I had addressed that one. Then finally is whether we want to prefer more charges or more sanctions against the persons involved, and on this matter, especially on criminal culpability. That the issue of criminal culpability is still open, and we will be inviting some people probably in the near future. But as of now, we dealt with the issues of administrative action against the individuals involved. Thank you, Honorable Speaker. If I may have not addressed one or two questions, it's
very well. Now we move to the second round. Senator Mtata.
Honorable Speaker, was there any clarification for us to respond to some questions that have been put to us?
Just listen to this box so that you
Sugar is running a bit low. There are many questions.
It's running low to everybody.
Okay, all right.
Yes.
Mr. Speaker, sir, to the witness from the Ethics and Anti-Corruption Commission, I would like to ask whether the Kenya Kwanza coalition document is unconstitutional and therefore null and void to the extent that its formula for sharing executive power violates Articles 10, 27, 129, 130, and 131 of the Constitution. Number two, if that's the case, who is to blame for approving the unconstitutional coalition agreement that resulted in forming a government? Number three, can you point this Senate to any hard evidence of criminal conduct which you have unearthed in your investigations against the Deputy President? And can you distinguish whether there's a circumstance where the Deputy President, or even me as a Senator, can walk into a place and be given a gift that I don't have to declare, irrespective of the amount of the gift? Because I engage officially and privately. So is there a situation whereby I can be given a gift of whatever magnitude that I don't have to declare? Thank you.
Senator Chute.
Thank you very much, Honorable Speaker. Honorable Speaker, let me first of all thank Bwana Abdi for many years' service he has given to this country, and we highly respect him. I want to refer Abdi to ground number 11 and also to his documents, page 7. Ground number 11 says, His Excellency Rigathi Gachagua bullied Kenya Medical Supplies Agency officials into awarding a tender for supply of mosquito nets to Crystal Limited. And in your letter on page 7, the Commission, let me read, the Commission is of the opinion that the conduct of the CEO, Terry Ramadhani, amounts to violations of leadership and integrity act, particularly section 10 and 11. Mr. Abdi, today as we speak, Terry Ramadhani is a deputy ambassador in India. And Mr. Mutuse, Honorable Mutuse, wants this house to get rid of the deputy president on the account of bullying somebody. Can you tell Kenyans, 50 million Kenyans today, as you stand there, do you want this house to impeach the president if you have already recommended some culprits to be given administrative, what do you call, action, and then you want us to impeach the president?
Senator Kamau. Githuku.
Thank you very much, Honorable Speaker. Honorable Speaker, I want to ask a question to the Deputy Chief Executive Officer. In the course of our investigation, is there anywhere that you have identified that the Deputy President of the Republic of Kenya, who you want impeached, influenced any tender award? Thank you, Honorable Speaker.
And the senator was elected by the people of Kajiado, Senator Sek.
Thank you, Honorable Speaker. My question goes to, or clarification goes to Abdi Mohammed. Mohammed, we have realized that there is a report from the ACC and a report from the Committee of Health of the Senate in regards to the, this issue of mosquito nets. I want to confirm that the contract was cancelled and the funds were not lost. I want you to demonstrate the role of this agent by the name Crystal Kenya Limited in relations to the Deputy President's office and more so regarding Gachagua. Thank you very much.
Senator Miraj. Okay, if you don't have any question, then log out. You may now proceed, and thereafter we'll have an opportunity for the counsel for the Deputy President to respond to the clarification sought.
Thank
5
you.
minutes.
Thank
Abdi,
you,
have 5 minutes.
Honorable Speaker. In fact, I'll take less than 5 minutes. Senator Omutata, I think he raised the issue of whether the agreement of the Kenya Kwanza document or Kenya Kwanza government document is unconstitutional. I think that one is only the courts that can actually find whether that document is unconstitutional or not. It's not within my ability or powers, or rather to comment about the constitutionality or otherwise, and whether the document is null and void, and whether it contravenes certain articles of the Constitution. The second one was who is to blame for drawing unconstitutional agreements or documents. I think that is also something that can be tried in court in my view. If anybody suspects whether this document is constitutional or not, I think the best thing to do is to try it in our courts, and they will of course give directions on what can be done. Now, the other one was whether we have investigated any criminal conduct against the DP. I think I had indicated clearly that we have not investigated the Deputy President for any criminal culpability or any criminal case as far as EACC is concerned. Senator Chute, thank you very much for the compliment. I appreciate. Now, the issue of bullying of KEMSA officers or staff, I think that came from the CEO himself, and he gave evidence in this House that will be considered by the House, whether it is something that can stand the test or not. As for Terry Ramadan, we did our bit in terms of recommending this lady to be disciplinary action be taken against her for her role in this particular procurement. But because I indicated we don't have the compellence powers to enforce disciplinary or administrative action, I leave it at that. And whether our recommendation is for the impeachment of the DP, ours was to respond to the summons that was given to us by this Honorable House. It is for the House to do, that is their job. I wouldn't want to go there. We never recommended, I don't want to go there. Then whether there was anywhere where the DP influenced any tender, no, we do not have that, and we never submitted that. All that we said is what I'm going to say in the next response, which was raised by the Honorable Senator for Kajiado County about the role of Crystal Kenya Limited and the connection between that company and the Honorable Deputy President of the Republic of Kenya. From the documents that we have and which we supplied, it is clear that this company, the directors are two sons of the Deputy President. Each one of them owns 200 shares. They are the only directors of that particular company. And that is the nexus between the Deputy President, Honorable Rigathi Gachagua, and that particular company. And that is our response as of now. So, Honorable Speaker, thank you very much. That's it.
Counsel for the Deputy President, we'll give you 10 minutes. Starting now.
Thank you very much, Honorable Speaker. I will share my minutes with my colleague Ndegonjiro. My questions are limited to the issue of the shareholder agreements. I'll be quick. The questions were asked by my learned senior and colleague and friend, Professor Ojenda, Catherine Muma, and Senator Omtata. I'll begin with the questions by my learned senior, Mr. Ojenda, and I'll begin with the second question he asked. He asked, is the relationship between the President and the Deputy President irretrievably broken? That's not a legal question, but in my experience as a Kenyan, there is no such thing as an irretrievably broken political relationship. Members of Jubilee, party I served as an advocate for, woke up in March 2018 to find their leader shaking hands with his opponent at Harambee House, and they subsequently found a way to work. A few months ago, the President and the Honorable former Prime Minister have found a way to work. There's no such thing as an irretrievable political relationship. Secondly, leadership constitutionally is not so much about how you feel. It is about your duty and your responsibility constitutionally. Your feelings must take a backseat to your duty to the people of Kenya. Secondly, I was asked about the counties. Now, when you look at these shareholder agreements, and again, if members will go with me to page 418, where you find the shareholder agreement between ANC, Ford Kenya, and UDA. Sorry? Oh, volume, sorry. I don't know how to increase the volume.
Council, sorry, Council. Members, I'm getting a bit lost when you say UNDA. UNDA, if spelling in Swahili is UNDA.
No, UDA. Sorry, I come from Kenya.
It's Democratic Alliance. If you use maybe the first make clear.
I'm sorry.
That it is United Democratic Alliance.
Yes. I'm sorry. We use acronyms. I'm sorry. It's the United Democratic Alliance Party. The full name of Amani is Amani National Congress Party, and the full name for Ford Kenya is Ford Kenya Party. So their agreement at page 429, you will note, Professor Ojenda, it does not talk about counties. the agreements seem to have been structured in regions. It talked about region. Now, I don't know what they meant by those regions, but what I can tell you is that at paragraph 20...
Also, I will allow Mr. Abdi to have a seat somewhere as you conclude.
Yes, as I said, Honorable Senator for Kisumu, at page 429, which would be paragraph 20, subparagraph O, that's the first proviso there was. Further terms, parameters, and details of the sharing of positions of responsibility in the national government pursuant to this article shall be contained in a separate schedule to this agreement, which schedule shall be negotiated and executed before the date of the general election scheduled on 9th August 2022. So this was not a final agreement. My understanding is that there were further schedules. I don't know what those schedules said. They are not available at the register of political parties. They may very well have included all the counties you asked for. Maybe Kisumu was in the subsequent schedule, I don't know. Secondly, the drafters of this, as I've said, were careful to stay within the confines of the Constitution, because at paragraph 22, subparagraph G, this is what they said. Notwithstanding the content of this article, the founding member parties hereby commit to make any adjustments that may be necessary to accommodate the development priorities of other parts of the country, to ensure equitable distribution of Kenya's national resources and wealth for the benefit of every citizen and every part of Kenya. So there was a proviso to ensure that the document was constitutional. And perhaps while I'm on that issue as well, I might as well answer my good friend Senator Mtata's question. I am not yet mercifully a judge. I cannot say whether the Kenya Kwanza coalition is unconstitutional. Somebody will have to move the court for that determination to be made. But what I did say was that in 2005 I had the privilege in participating in a case involving the MOU for NAC. And that one was struck down because the law had no underpinning making room for it. And which brings me to the question raised by Senator Catherine Muma, which is the political parties section. There's actually not one, there's several. If you go to Schedule 3, sub-paragraph C, B, D, and E. Let me read them out for you. So B deals with the policies and objectives of the coalition. That's B. D deals with organizational structure and management of the coalition, including county structures and systems and county government bodies, which you'll also find in these agreements. And then C, the overall structure of the coalition. And then E, the criteria or formula for sharing of positions in the coalition. That's what it says. Positions in the coalition structure, roles, and responsibilities within the coalition. So that's what it says. So most political coalitions have interpreted that to mean, and it's been healthy thus far. I think it's helped, in my view, this country become a bit more stable and united. And I think I've answered all those questions that had to do with the question of the shareholder agreements. Unless members had any clarification, I rest.
Thank you, Council, for DP. Council Ndegwa, you have something to pick, or do we conclude it at that?
Specific questions and clarifications. Noting at the mood of the House, perhaps I can indulge the House. I respond the same after lunchtime.
No. After lunch, we are going straight to your main witness.
Very well, Mr. Speaker, sir.
So what we can do, Council Ndegwa, allow me to invoke Standing Order 34.2A for the convenience of the House to add 5 minutes. So the House will rise at 1:05 instead of 1.
I am well guided by your wisdom.
Yeah, Mr. Speaker, sir, there were two questions for the National Assembly side to respond.
Okay,
two questions.
then let's do this. Let's do this. Instead of the House rising at 1:05, we will rise at 1:15. So, Council Negwa, you'll take your 5 minutes, and then the rest shall be given to the Council for the National Assembly.
I am well guided, Mr.
Speaker, sir, the witness is asking if he can leave the
Absolutely.
platform.
He's discharged.
Thank you very kindly, Mr. Speaker, sir. I was asked to clarify by Senator Joyce Carrill why I am dealing with the report from the Senate and what am I driving at. The report to the Senate is intended to indicate that none of the participants in that tendering process ever benefited from that particular process. All the 17 companies, none of them benefited, and that as a result or as a consequence of the failure to proceed to the next levels, the country did not lose even a single cent. A question was put to me why I am looking at the submissions by various parties and not going to the observations and the recommendations by the Senate. And just like a skillful legal surgeon, I have been able to point out various findings, submissions. For example, the submissions finding themselves at page 222, paragraph 107 and 106, 107 and 109 find themselves at the recommendation, at the observation of the Senate at page 271. So there is serious correlation between my findings as submitted by various parties who appeared before the Senate and the observations made by the Senate. So I dealt largely on what the Senate found as opposed to what the Senate had during the proceedings. Number two, Mr. Speaker, sir, clarification was sought as to why the bid failed, and although that will be dealt with at length, permit me to draw the attention of the Assembly to page 108 of the volume 3 of the Deputy President's Band of Documents. You'll find a letter from KEMSA dated the 5th May 2023, being a notification to Shobika Impex Private Limited. And it reads, the reference is made to the above tender and advised that the tender was unsuccessful due to the following reasons. 1, tender security was not paginated. Number 2, please plan to collect your bid security from the procurement office immediately. It may be of interest to note the date when this letter is being generated is the 5th of May. It will also be of interest to note when the alleged bullying and intimidation occurred. This letter precedes the alleged bullying, alleged intimidation. Number 2, Mr. Speaker, sir, this letter is voluntarily being issued and being generated by KEMSA themselves at their own intuition, as opposed to being triggered by any external officer, in this case, the person of the Deputy President. In their own volition, KEMSA triggers and invites Shobika to come and collect their bids, and on witness, Mr. Speaker, sir, the witness confirmed that this is always the end of a failed bid. Finally, Mr. Speaker, sir, permit me to draw the attention of the Assembly to the matter in issue. That is at page 36 of the volume 1 of the impeachment motion. The matter in issue that is subject for interrogation, Mr. Speaker,
45 seconds.
as I pen off, is not whether the tenders were responsive, whether the country lost any money, whether investigations were done, whether there was conflict of interest, whether there were gifts that accrued therefrom. The question in issue is, did the person of the deputy president bully the officer? Was there evidence? So let us not lose ground or focus on the ground on the matter in issue, so that we focus and we put the train on rail. Thank you, Mr. Speaker, sir.
Counsel for the National Assembly, take us to the rise of the House.
Mr. Speaker, sir, how many minutes? 10?
You have 9 minutes.
Yeah. Yeah, thank you, Mr. Speaker, sir. I am here to respond on behalf of the National Assembly on only 2 questions. Mr. Speaker, sir, listening to the Deputy President's side, I believe they have misunderstood the nature and context of ground number 11. And there was a question by the Senator whether we have substantiated ground number 11 on bullying of KEMSA officials. Secondly, there was a question also on whether there was loss of public funds in this tendering process. Mr. Speaker, sir, allow me to answer the first question by mentioning that the Deputy President of the Republic of Kenya is a high-ranking state official. The Republic of Kenya, the polity of the Republic of Kenya is based on certain fundamental national values and principles of governance. In addition, there are provisions on leadership and integrity. If you look at the provisions of Article 75, starting with 73, then you conclude with 75. There is an express prohibition on conflict of interest when it comes to all state offices. Now, to contextualize that question, you have to look at the purpose of impeachment. The Deputy President, being a high-ranking state officer, means that there is a constitutional process for bringing him into account to question his conduct. And that is why you have this process of impeachment. Impeachment is about political responsibility. It's about governance. Impeachment is not about criminal culpability. It's not about gathering evidence for purpose of taking him to court. It's about bringing him to account on what he has done from a political standpoint, and that issue of the distinction of criminal processes from impeachment has been clarified by the Supreme Court of Kenya. The Supreme Court of Kenya, in the case of Mike Sonko, was expressed clear and unequivocal that impeachment is about those values, ethos in Article 10 and the provisions of leadership and integrity in Chapter 6. Now, if you look at the way ground number 11 has been coached, ground number 11, Mr. Speaker, sir, ground number 11 talks about gross misconduct. Now, the Supreme Court of Kenya has interpreted what amounts to gross violation, which in context then means gross misconduct. And the conclusion is that when you violate these core values in Article 10 and the provisions of leadership and integrity, then you are guilty of gross misconduct. You are guilty also of gross violation of the Constitution. Sometimes you are guilty of abuse of office. So to put it in context, if you look at that charge that we have put in ground number 11, it's bullying of KEMSA officials. Now, that fact of bullying, and we have been more specific. If you look at the charge, we have mentioned the specific clause of legislation where the act of bullying has been prohibited. And this provision if you look at the provisions of the Leadership and Integrity Act, the provisions of the Leadership and Integrity Act specifically prohibit bullying of bullying by state officials. And in that context, then you can see that in terms of the allegation that we are making and the evidence which has been submitted before this House, especially that call which was made by the Deputy President. The call was made by the Deputy President to a KEMSA official. Why would the Deputy President be pushing the interests of a commercial, the commercial interests of a private company? That is crystal clear when you look at his own admission in his response to this allegation. The Deputy President has admitted that he lent the sum of Kenya shillings 200 million to Crystal Company to acquire some hotel in Nyeri. This is the same company which the Deputy President is making a call to KEMSA to consider. And a senior KEMSA official, in this case the Managing Director, goes to EACC in a tender process.
Mr. Speaker, I just wondering which clarification my learned colleague is responding to, because the time for submission is in the evening.
Yes, Council from the National Assembly.
Yes, Mr. Speaker, so I'm just concluding that it's an impeachable offense to make the link.
Very well. Now conclude.
Yes, so, Mr. Speaker, so if you look at then the evidence which has been submitted by Dr. Mulwa, that he received a call from the Deputy President, who is a high-ranking state official, to go to EACC, and then he went to EACC to collect evidence, which EACC had gathered for purposes of submitting that tender to the Deputy President or his conduct, in this case his son. Then what we are saying is that that act by the Deputy President then constitutes a violation of the provisions of the Leadership and Integrity Act, specifically Section 34 of the Leadership and Integrity Act, and that amounts to bullying. And to that extent, we are submitting that charge has indeed been substantiated in all its four corners. On the second question, and here again, it appears there is a misnomer. To prove an economic crime, you don't need to prove that there was loss of funds. An economic crime in this case occurs when a sitting Deputy President, in a tendering process, he makes a call which the recipient then interprets in a different way, perhaps to influence the tendering process, or perhaps to for certain decisions to be made in favor of that person. And the person who is making the call is a sitting Deputy President. That is why then the provisions of the Constitution prohibit
Mr.
conflict
Speaker,
of interest.
if you may, I think my learned friend has enjoyed a lot of latitude in respect to responding to issues that were not sought for clarification. I was taking note of all the issues that were sought. And the issue that Council is responding to are not among those that were sought. And if they were, then he needs to indicate from which particular senator did seek that.
Council for National Assembly, reserve other matters for submission.
Yeah, Mr. Speaker, so I'm responding to the question of whether there was loss of funds.
That was not sought for clarification.
It was sought by a senator. And,
it was sought.
It was sought.
It was sought.
Yeah.
1 minute.
Yeah. So, Mr. Speaker, sir, in this case, evidence has been led. If you look at it from one perspective, evidence has been led by Dr. Mulwa that indeed there was a delay in this procurement. Secondly, fewer nets were supplied. Thirdly, there was a question concerning the costs incurred in this tendering process, and the evidence was that 55 million shillings was incurred in this tendering process. It came from the mouth of Dr. Mulwa. So to that extent, you can see there was some loss. Whereas the tender was financed by the Global Fund, from our own perspective, we lost a lot, not only from a monetary perspective, but also from the other factors. What about Kenyans who did not access this malaria, these mosquito nets, and were exposed to malaria? Is that not a loss which is non-monetary, and therefore, to that extent, one can make a conclusion that the conduct of the Deputy President in this regard violates the provisions of Section 34 of the Leadership and Integrity Act. Mr. Speaker, so I end by stating that we have fully substantiated ground number 11, and it's one of those grounds where the evidence is the president himself through a phone call that he made to Dr. Mulwa, and he has admitted making that phone call. Thank you.
Thank you. Now, honorable senators, we are going to start with the deputy president at exactly 2:30. If you keep time, we're going to save time so that we don't have to ring the bell for a quorum. If we can start taking the evidence from the deputy president at 2:30, then we'll be able to manage our time going forward. You may now rise. Honorable senators, it is now 1:15, and having concluded the business for which I extended the hours of the sitting pursuant to Standing Order 34-2A, the Senate stands adjourned until today, 17th of October 2024 at 2:30 p.m. Two hours to present his case, and thereafter the National Assembly will have 1.5 hours, because they've also consumed half an hour of the 2 hours that had been granted to them yesterday. So you had borrowed 10 minutes, you ended up consuming 20 more minutes, as per our record. Council, this is not a matter to debate.
Mr. Speaker, so I just wanted to clarify that we had borrowed 10 minutes.
Yes, you borrowed 10 minutes, but you ended up consuming 20 more.
We did get that indication, Mr. Speaker. In fact,
Now
we had
you're getting the indication.
Yes. We had budgeted our time knowing that we had 1
Just
hour, 15 minutes.
Consume the 1 hour and a half, and then let's see where that takes you, and we'll be able to engage when you consume the 1.5 hours.
We are most obliged, Mr. Speaker, sir.
Thank you. Senior Counsel Paul Mwite, if you're ready, you may usher in your witness.
Mheshimiwa Speaker, just to get clarification, I was under the impression that the National Assembly will proceed and close their case, and that then Counsel for the Deputy President will now present the Deputy President, who is the only one that we are calling as a witness, and that thereafter the National Assembly will make their closing speech, and we will have the opportunity at that time to also make our closing speech. So I would like to have clarification.
Very well, Senior Counsel. Maybe I'll read the whole program all the way to the end.
Thank you.
You will proceed. Of course, for the record, I will ask the National Assembly to officially rest their matter to allow you usher in your witness. Once your witness takes to the stand, you have 2 hours to present your case. The National Assembly has 1.5 hours for purposes of cross-examination. Thereafter, the senators will have 1 hour to seek clarifications or ask questions. Once that is done, The Council for the National Assembly will have 1 hour to make closing remarks. Likewise, the team of the Deputy President will be given 1 hour to make its closing remarks. Once that is done, the Senate will move into a closed session as per our rules of procedure. So that is the program for this afternoon.
I'm now very clear, Mheshimiwa Speaker, and I thank you. The situation is now clear. But just before my colleagues on the other side close their case, can I, through Mheshimiwa Speaker, ask whether the National Assembly still wishes to call a witness whose affidavit was filed, the governor of the county government of Nairobi, Johnson Sakaja. We have a copy of his affidavit. Is he going to be called or not called? Because if the National Assembly is not calling that affidavit, whose affidavit is part of the record and was availed to us, that affidavit, Mheshimiwa Speaker, contains allegations that are extremely injurious to the Deputy President. So if he is not going to be called, we will be making an application for that affidavit to be expunged from the records of this Honorable Senate. Thank you.
Council for the National Assembly, you had listed quite a number of witnesses. Are you going to call all of them, or are you going to, for the record, are you going to close your case where we are?
Mr. Speaker, sir, on behalf of the National Assembly, we shall close our case where we are. Mr. Speaker, sir, if you are, with your permission, I could respond to the submissions by my learned senior, Mr. Paul Mwite.
Please do.
Mr. Speaker, sir, at the beginning of the proceedings that we are currently going through, this House did invite parties to give indications as to the witnesses they wanted to call. Mr. Speaker, sir, we gave the list of the witnesses whom we thought were relevant for purposes of clarifying what we needed to have clarified. If Council for His Excellency the Deputy President did not do as much or did not take advantage of that window that was open, surely they cannot blame us for it. But secondly, and more importantly, Mr. Speaker, sir, yesterday, in the course of the deliberations in relation to one of the preliminary questions that had been raised, you gave a very clear ruling on the intendment of Rule 20 of the rules of this House. In particular, the understanding was that every material that was forwarded by the Speaker of the National Assembly to this House constituted evidence in support of the allegations that are the subject of inquiry by this House. It then follows that if the application that learned senior counsel, Mr. Paul Mwita, is making were to be looked at in its totality, he is actually making an application to amend or to remove certain aspects of the evidence from the record. Mr. Speaker, sir, that is an issue that you settled and rested yesterday. I don't think it's an issue that is open for re-intervention. Mr. Speaker, sir, it should also suffice to note that even on our side, there are affidavits that form part of the record that came from the National Assembly. In particular, there is an affidavit sworn and which is in favor of His Excellency the Deputy President, an affidavit sworn by the joint executors of the will, that is Mr. Njoroge Rigeru, together with the other executors. It is part of this record. We have not made an application to have it expunged. We have an opportunity to deal with it when the time comes. Lastly, Mr. Speaker, sir, The nature of the sittings that this House currently is undertaking is quasi-judicial. It is inquisitorial in nature. If that is to be the correct position, Mr. Speaker, sir, then the rules of evidence as we know it in the court would not necessarily bind the proceedings, because what has been presented is the subject of what the honorable senators are going to investigate. At the end of it, it is not a judgment that they will be giving, it will be a vote. I rest my case, Mr. Speaker, sir.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, first and foremost, the affidavits that my colleague, my learned friend, referred to were sworn by the executors of the will of the late brother to the Deputy President. They were filed in the National Assembly, in the proceedings in the National Assemblies. They were never filed here as affidavits of witnesses that we proposed to call. With regard to the affidavit of Governor Sakaja Johnston, it was specifically filed in the Senate, an affidavit of a witness that they intended to call. That affidavit has material injurious to the Deputy President. Mheshimiwa Speaker, we were looking forward to cross-examining Governor Sakaja so as to bring out the truth to assist this Honorable Senate to make a decision. If he is not being called, and in fairness to the Deputy Governor, all that we are asking is that affidavit be expunged together with the affidavit of Peterson Jomo, who they are not calling now, and also the affidavit of Mercy Wajau, who is not being called. It is not fair to file affidavits containing information allegations injurious to the other party, then ask that those affidavits to remain as part of the record without calling them and availing them for cross-examination. So my application is that the 3 affidavits be struck out. Thank you.
Mr. Speaker, sir, just for clarity, there is absolutely no new material that was presented after the material that was sent to this House from the National Assembly. For instance, the affidavit by His Excellency Johnson Sakaja is to be found at volume 1 of the documents that have been filed.
Maybe Counsel for the National Assembly, let me get it clear.
Yes,
the affidavit by the Nairobi governor, was it filed after the proceedings of the National Assembly, or it forms part and parcel of the proceedings that came from the National Assembly?
It forms part and parcel of the proceedings that came from the National Assembly. In particular, Mr. Speaker, sir, all those affidavits form what constituted part of what came into through public participation.
So just hold in that so that we make progress. Senior Counsel, you have indicated that the affidavit by the Honorable Governor for Nairobi did not form part of the documents that emanated from the National Assembly. Now, the position as held by the Council of the National Assembly is to the contrary. These are things we can settle now. Did it come with a bundle of documents from the National Assembly, or it was filed after the Senate was seized of those documents?
Mheshimiwa Speaker, I have been corrected by my colleagues. The affidavits where the affidavit by Governor Johnson Sakaja was actually part of the public participation. So it was part of the record of the national.
So now let's move to the two.
Yes.
Let's move to the two. Now, have a seat, Senior Counsel. Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Yeah, respond to the two more affidavits, because the contention from the Council of the Deputy President is that they were filed after the record was received from the National Assembly by the Senate.
Mr. Speaker, sir, I reiterate the position that we earlier on gave, that there's not any single document other than the document that was admitted yesterday pursuant to our application that came in after the record had been presented before this House.
So the affidavits were not filed after the Senate received the bundle of documents from the National Assembly?
Absolutely not.
Can you lead us to the volume and the page containing these affidavits from the National Assembly?
Mr. Speaker, sir, just give me 1 minute to consult with my colleagues here. I identify it, then I bring it. It's not an issue that we had anticipated.
Yeah, so that we settle this matter.
Most of that.
Yeah, let's settle it.
It is not, Mheshimiwa Speaker, it's only the affidavit of Peterson Jomo that was filed in the Senate. It did not form any part
Very well,
of the
Senior
National
Counsel.
Assembly.
So then let's settle that one and we make progress. We need not argue on this matter.
Mr. Speaker, sir, I think what happened is that we skipped the opportunity to identify the documents from both sides of what had been filed. The documents that we filed yesterday has a volume 8. That is the document that contains the affidavit of Peterson Jomo.
So it is that affidavit, if you go to the Senior Counsel, it is that affidavit that they're looking forward to cross-examining the deponent. Now that you've closed your case, the argument from the Council of the Deputy President is, how then are we going to test the truth of those averments? What say you on that?
Mr. Speaker, sir, I did give an indication that, number one, at the commencement of these proceedings, any party who wanted to cross-examine any of the deponents of any of the documents had an opportunity, upon your invitation, to invite such parties to appear before them. If our counterparts appearing for His Excellency the Deputy President did not find it appropriate to call that witness at that point in time, they cannot now hold us to say that you had said you'd call this person, you will not call them. Because the person we were to call was for purposes of clarifying what we thought was important for us. Now, this being an inquisitorial proceeding, a quasi-judicial proceeding, Mr. Speaker, sir, I think it would be a stretch to expect that if we didn't call or if we didn't avail any of the witnesses that were mentioned in any of the affidavits, then as of necessity that follows that record or that affidavit needs to be expunged. That's what I was saying. Pursuant to your ruling yesterday, that is evidence and material that was presented yesterday. It forms part of your record.
Now, before I give my way forward, Senator for Nairobi City.
Honorable Speaker, the counsel that are appearing in this case are people that I hold in extremely high regard. Senior Counsel Paul Muite appears to not have the confidence of the judges sitting here that we know how to treat evidence contained in an affidavit that is not tested at cross-examination. Even the judges you appear before in the courts that you practice in know what to do with evidence of a person who is not availing themselves for cross-examination. So, Honorable Speaker, I really don't understand what the contention is, because we sitting here as judges know how to treat that evidence, and I wanted to take this opportunity to calm the anxiety of Senior Counsel Paul Muite that indeed we do know what to do with such evidence.
Now, so that we make progress, Senior Counsel has raised an important matter, which matter has been responded to by the Counsel for the National Assembly. Now, honorable senators, there is an affidavit sworn by one Jomo Mushira who had been listed to appear as a witness for and on behalf of the National Assembly. The National Assembly has closed its case without calling that particular witness, and yet there's an affidavit that the counsel for the Deputy President will not have an opportunity to cross-examine. The question, as you retire at the end of this hearing, is to look at the probative value of that particular document. Senior Counsel Paul Mwite, your point is valid. The senators have noted.
Because this is an important, very important institution with a judicial function, court of record, permit me to put on record that there is a slight distinction between counsel and the client. I have absolute full faith in honorable senators, including my friend, the senator for Nairobi, but I am carrying out instructions of my client.
Yeah, so I've given direction on this particular matter. Let us move forward. Having said that, Senior Counsel Paul Mwite, if you're ready, you may now usher in your witness.
Mheshimiwa Speaker, we are anxiously waiting for the Deputy President. My colleagues can stand here, can stand in. For me, let me make inquiries and find out where he's held up. We certainly wish to call him as a witness.
Very well. Yes, what is the point of procedure, Senator Boni?
Unprecedented, to the extent that when we stand down business in this House, it normally arises from a communication from the chair that you're temporarily, for a specific time, suspending the proceedings. You have not done this, and we are seated in the chamber. The mess is in place. I do not know whether we want this to be the new standard, Mr. Speaker. Could you guide us? We have no idea how long we're going to wait. And time is running, Mr. Speaker.
Honorable Senators, at the rise of the House at 1:15, I made it clear that upon resumption, the Deputy President was going to take the stand. We came in here, I communicated the program for the afternoon, and I said we're going to execute it with military precision, owing to the fact that we need to conclude business today. Senior Counsel Paul Mwite indicated that he cannot get hold of his client. That is not the concern of this House. So time is running. Order. Order, honorable senators. Order. The floor is available to the Deputy President and no other senator or no other element.
Well, the Speaker of the Senate, Honorable Amason Kingi, currently presiding over the business of the Senate this afternoon, has just directed that the floor at this particular juncture is not available to any other senator owing to the...
Enoch, I used very basic English. I know you. You have such a wonderful grasp of the language. You need not to get any clarification.
It is exactly 15:04 p.m. this afternoon, being the 17th day of October 2024. The afternoon sitting of the Senate this afternoon was to kick off with the Deputy President taking the stand, bearing in mind the DP, His Excellency Rigathi Gachagua, is the sole witness in the case where the National Assembly, through the move of the motion, Honorable Mwengi Mutuse has leveled 11 grounds for impeachment of the Deputy President from office. We have already dispensed with the prosecution side, and during this afternoon sitting, immediately after the commencement of business, the council representing the National Assembly have confirmed to the House that they do not intend to call more witness in regards to this case. The counsel for the Deputy President had requested the House through the Speaker that any evidence where the witnesses are not appearing be expunged from the record. It is a moment of waiting at the Senate this afternoon as the House awaits the arrival of the Deputy President, Rigathi Gachagua, who is set to take the stand at the Senate this afternoon and prosecute his case through himself as well as his defense, and convince senators why the 11 grounds listed for impeachment should be quashed by the House. Our dear viewers, the motion for the removal by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, has 11 grounds where the National Assembly is seeking to have the Senate uphold the charges, or at least one of them, to have the Deputy President cease to hold office today. The mover of this motion, Honorable Mwengi Mutuse, who also serves as Kibwezi West lawmaker, has told senators for the better part of yesterday and today that his desire through this motion is that the House finds the Deputy President to have committed the offenses listed in this motion. And this afternoon, the defense of the Deputy President, led by Senior Counsel Lawyer Paul Muite, will be seeking to water down those charges by the evidence that they will be presenting before the Senate this afternoon. And to just take you through probably some of the charges that the Deputy President will be seeking to counter this afternoon is charge number 1 on the gross violation of the Constitution and any other law. This is pursuant to Articles 150, subsection 1BI of the Constitution. Charge number 2 in the impeachment motion by Honorable Member for Kibwezi West. The Honorable Member alleges in his motion that there is gross violation of Articles 147 subsection 1 and 152 subsection 1 of the Constitution, where the Deputy President is being accused of undermining the presidency. Under Article 147 subsection 1 of the Constitution, the Deputy President is the principal assistant of the President and shall deputize the President in the execution of President's function. In this motion, the Honorable Deputy President is accused of going in contravention with cabinet resolutions on matters evacuation of people residing along Nairobi River, and that shortly after His Excellency, shortly after being in contravention with the cabinet resolution, the Deputy President made public a statement opposing the Nairobi River riparian execution orders. According to the mover of the motion, this is undermining the resolutions by the cabinet. Under charge number 3, again on gross violation of Article 6, subsection 2, Articles 10, subsection 2A, Article 174, and Article 188, and the 4th schedule of the Constitution, where the Deputy President is accused of undermining devolution. The mover of the motion in his motion states that on the 20th of September 2024, His Excellency Rigathi Gachagua, recklessly and mindful of the high calling and dignified status of the office of the Deputy President, unlawfully interfered with the running of the Nairobi County government by holding a public rally in which he incited citizens against lawful directives by the Nairobi City County government on the planning and relocation of markets. This is just some of the grounds listed or some of the annexes under charge number 3, where the Deputy President is set to defend himself on these charges, among others.
Senior Counsel Paul Mwita. Your time started running.
Mheshimiwa Speaker, may I...
Let me just conclude, Senior. Your time started running at the time I requested you to usher in your witness. You indicated that you're getting hold of your witness. We'll give you all the time you need to get hold of your witness, but to let you know that the clock is running and it's running on your client. You can take all the time, but his time is running out. After 2 hours, he's not appeared, the chair will make a ruling pursuant to the rules of procedure.
Mheshimiwa Speaker, may I start first and foremost by expressing apologies and regrets that the Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. The sad reality is that the Deputy President of the Republic of Kenya has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
Order, honorable senators. Order, honorable senators. Senator Kajwang. Now, Counsel for the National Assembly, you have had Senior Counsel Paul Mwita for and on behalf of the Deputy President. Considering that this is a time-bound process, What is your reaction?
Mr. Speaker, sir, this is a house governed by the rule of law. We truly empathize with the difficulty that His Excellency, the Deputy President, has found himself in. But, Mr. Speaker, sir, pursuant to Rule 11 of the rules governing this process, if I may, with your permission,
maybe Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Just take a seat before you make your rejoinder. Senior Counsel Paul Mute, having said whatever you've said, what is your proposed way forward so that a reaction can be put from the National Assembly? Are you telling us we wait until your client gets here? What is your proposed way forward?
Mheshimiwa Speaker, I have just received this information. My proposal is that you give me at least the rest of the day. I would like to go and have an assessment of his situation and maybe even come back here by 5 p.m. Right now, I would like to make an informed sort of situation after I see the Deputy President and I see the doctor, Mheshimiwa Speaker, at least an hour or two. Yes, thank you.
Very well. Counsel for the National Assembly.
Mr. Speaker, sir, having very keenly listened to my learned senior colleague, Paul Muite, Senior Counsel, it puts us in a bit of a difficulty because whereas we may want to empathize with the situation, there appears to be no indication from their end as to a specific proposal. Mr. Speaker, sir, this being a house governed by rules and this process being a time-bound process, I will draw your attention to Rule 11 of the rules of this House. If I may read, Mr. Speaker, sir, that where the National Assembly or the President chooses not to appear before the Senate, that fact shall be put on record and the Senate shall proceed with its investigation without further reference to the National Assembly or the President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the President. Mr. Speaker, sir, I think this rule would give us guidance we may proceed. If it becomes necessary, then any additional material may then be availed. This is a time-bound constitutional process, Mr. Speaker, sir. I'm most obliged.
Let me pick the wisdom of my wonderful senators before I make my decision on the way forward. Now, I understand that all of you are wise men and women.
Speaker, can I just say a word?
Yes.
I've heard what Senior Counsel Paul Muite has said. And, Mr. Speaker, you have made it quite clear that these proceedings are time-bound. It's not so much about the situation in which His Excellency the Vice President finds himself. It's about the Senate complying with the provisions of the Constitution. That within that time frame, you must make a decision. Reading the standing orders that my learned friend, Mr. Rick Gumbo, has referred to, it would be useful to this House if Senior Counsel Paul Muite could probably give us a way forward in terms of the the time limitation that the Senate has. I'm saying this because we don't want somebody to say that the Deputy President was not given an opportunity to be heard. I think the Senate will want him to be heard. But knowing the time limitation, what suggestions does the Senior Counsel have to ensure that we keep within the time parameters? At the same time, the Deputy President is given his space to defend himself.
So we have two sides. We have the minority side and the majority side. I will only allow the two leaders to speak. If you need to consult in the next 1 minute, now, honorable senators, our standing orders have not been suspended yet. It is only Senator Mazayo and the majority leader who, the rest, take your seat. The rest, please take your seat. Order, honorable senators. considered the two sides, my directions are as follows: that we will suspend this sitting and resume at exactly 5. So the Deputy President, we expect the Deputy President then to take the witness stand at 5. This is a time-bound process, unfortunately. It is so ordered.
For impeaching the Deputy President, and the senators have been hearing from the parties. The National Assembly has produced witnesses who have been issuing their accounts to the Senate, and of course it has involved cross-examination, and the Deputy President was scheduled to take to the stand. He is the sole witness in this impeachment trial. Among the grounds that were advanced by the National Assembly include the gross violation of various articles of the Constitution,
Order, honorable senators. Senator Boni, please take your seat. Now, honorable senators, I did suspend the sitting of this House to allow Senior Counsel Paul Mwite for the Deputy President, one, to locate his client and report back at 5 so that we may proceed with these proceedings. Senior Counsel Paul Mwite, you may now inform the House so that we proceed.
Mheshimiwa Speaker, through you, I would like to inform honorable senators that I've been able to contact the doctors at Karen Hospital. There are a number of doctors, a team of doctors, who are looking after the Deputy President. Because of his condition, I was not able to directly talk to him on the advice of his doctors. He said he must have complete rest for the time being. I was, however, informed by his doctors that he is currently suffering intense chest pains. I did not want to inquire beyond that, Mheshimiwa Speaker. But just in order to perhaps save the time of this Honorable House, let me, as I sit down, invite Mr. Speaker and the House to look at Article 145 of the Constitution, Article 6. Mheshimiwa Speaker, Article 6 of Article 145 says, if the special committee reports that the particulars of any allegation against the President, of course it applies for the Deputy President. If you go to B, have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. Mheshimiwa Speaker, we are aware that this Honorable Senate made a decision to hear the charges in plenary, so that what we are doing in these proceedings, I would suggest and submit we are proceeding under Article 6B. And under Article 6B, this House, by the Constitution, is obligated to accord the Deputy President an opportunity to be heard, which is why Rule 11 of the standing orders of this House specifically provides, Rule 11, where the National Assembly or the President chooses not to appear. And I would like to submit that the Deputy President has not chosen not to appear. The choice of the language chooses to appear in Standing Order number 11 is to be read with the Constitution Article 145, Article 6, which obligates this Honorable Senate to accord the Deputy President an opportunity to be heard. So I do leave the matter in your hands, Mr. Mheshimiwa Speaker and Honorable Senators. I would suggest Article 145, the sub-article I've read, sub-article 6B, doesn't have a time limit of 10 days. Give the Deputy President, in the interest of justice, given the weight of removing a Deputy President from office, give him a couple of days. I thank you.
So if I get you correctly, Senior Counsel Paul Mwite, it is your application to the Senate that your client be given a couple of days. Now, a couple of days doesn't mean much.
That is the application. What I had in mind, I would add the word humbly requests Mheshimiwa Speaker and this Honorable House, the Senate, a couple of days I had in mind up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself. I thank you.
Counsel for the National Assembly.
Mr. Speaker, sir, permit me to start by registering our greatest sympathies and empathies and from the team, the National Assembly. Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned senior counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did sit, did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that the matter at hand from a committee perspective, but that the whole House would then be determining the matter. It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did gazette the 16th and 17th of October to be the days assigned for the hearing and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard does not have to be oral. The rules of this House permit that parties appearing could elect to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency, the Deputy President, has participated robustly in the proceedings, both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, if my memory serves me right, let me just make a quick reference. Before the National Assembly, His Excellency the President did file a response dated the 8th of October 2024. When the proceedings before this House began, His Excellency the President, the Deputy President again filed a very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point in time, His Excellency, the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us, because our expectation would be that His Excellency the President would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves in, having also very keenly heard learned senior counsel speak, matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, sir, matters held cannot be given timelines. There cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty that we'll be able to proceed on that assigned day. Mr. Speaker, sir, we would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law in mind. Mr. Speaker, sir, because I earlier on submitted that Article 50 provides for an opportunity, provides for the right to fair hearing, and that fair hearing does not necessarily have to be oral, we have had practice in our Supreme Court where dealing with some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have, in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight those documents and pleadings that have been filed. In this occasion, because His Excellency the Deputy President has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. On our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter, we are willing to take the painful decision to forgo the cross-examination of His Excellency the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency the Deputy President. Mr. Speaker, sir, we urge that if I had my learned senior colleague, Mr. Paul Mwite, senior counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 of those rules dictates that once the hearing has commenced, it shall proceed up to the end. It does not provide for an option for the House to adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the proceedings before this House, we urge that being a country, being an organ of a constitution that is that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word before you give your directions. I'm most obliged.
Mr. Speaker, just briefly, in these proceedings, we are governed by Article 145. And there is a very unique provision in Article 145 that you don't find in legislations to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, Sub-Article 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find ourselves in, because the makers of this constitution knew that when processes are time-bound, they must be a safety valve. Article 145, Sub-Article 5, which applies mutatis mutandis in relation to the removal from office by way of impeachment of the Deputy President, states as follows. The President, and for that matter, it should be read, the Deputy President, shall they have the right to appear and be represented before the special committee during its investigation. Now, the point that I want to make, that not in a lot of legislation you find the right to be represented highlighted, because the Deputy President can elect to be represented either by his advocate or by him appearing in person, or having both the Deputy President and his advocate to appear. Now, I want to put before the Senate, because a lot of you have this problem a lot of time during the elections. If, in accordance with the election law, you are required to subscribe your nomination papers on a certain day, and you fail it, you're running for president or deputy president, and you're told that you must present your nomination papers on a certain day, as it is there in the law, would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you any accommodation. You'll be out, and there are a lot of decisions on this matter. I want to talk to this Senate very frankly, that Senior Counsel Mwite was basically giving evidence. He has not told us well, or if he has told us, the medical institution where the Deputy President is. But for the Deputy President to fail to bring evidence, credible evidence before the House, that he's been admitted, even that evidence that has been admitted to a medical institution, we don't have it. We will rely on the evidence from my senior counsel, Paul Mwite. That is evidence. But in practice, I can say without a fear of contradiction, there are many times where people are represented even in medical documents, and later on they've been found to be fake, if I may use that word. I think the thing that the Deputy President should have done, we should have had one of the doctors here, at least to tell us about his admission, and about his condition, because up to 1:15, the Deputy President was here. He was not evacuated from here in an ambulance. And if I can give evidence from the bar, he went to his office, and again, there's no evidence that he was evacuated in an ambulance. He went to Karen Hospital in himself to check at the hospital. So I think our constitutional duty is to live by what the Constitution requires of us. The greatest prejudice, for me, I was looking forward to cross-examine the Deputy President. But unfortunately, the story that has been told does not include cross-examination of the evidence of the Deputy President, which is on record. But because we are time-bound, and as my London friend Eric Gumba said, we are prepared to go by the evidence in record. The prejudice is to us. The sickness of the Deputy President is affecting us more because we would want to cross-examine him. But he has evidence in record which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the Deputy President would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this health condition in which the Deputy President is, and I sympathize, may be opportunistic in the absence of medical evidence from a doctor. It may be opportunistic. And I saw him when he came in. I'm not a doctor, but there was nothing to suggest that he was in the condition that Honorable Counsel has been talking about. So do the senators now turn into a jury to make a decision on the basis of evidence presented from the bar by senior counsel without no documentary proof of where the Deputy President is and what ailments he is suffering for? I think the more important duty for this Senate is to comply with the Constitution. And we urge you to comply with the Constitution and proceed with the hearing of this impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, Honorable Senators, we all live in Kenya, and I would like to make this submission. These gadgets we have here capture every word uttered accurately, so that if I was found tomorrow to have lied to these senators, sanctions can be brought on me. And I would have thought that that fear of telling a lie to this Honorable Senate, to me, is more powerful than even bringing a medical report. We've had many medical reports generated outside hospitals. We see them in courts almost on a daily basis. Mheshimiwa Speaker, you will remember the rush that was there when I was asking to be given up to 5 p.m. And it was a rush. Was I to fail to come back to this honorable house at 5 p.m. waiting for a medical report when the doctors there are busy attending to their patient, the Deputy President. Medical reports, I can bring. If I've told lies, that is something that can be established. And my learned friend, Mheshimiwa Honorable Orengo, talks about giving evidence from the bar. When I was learning, they are seated down when he's giving evidence from the bar about some cases filed in Malindi that I'm not aware of. Perhaps he should have given us a copy of that. Mheshimiwa Speaker, Article 145, Sub-Article 6 is clear, and I do not want to take time of this august House, Senate. Going back to it, it applies, and I would plead with you and with honorable senators to give us until Tuesday to see whether the Deputy President will be well enough. No one decides when to get sick and when not to get sick. I am sure many honorable senators here will have a story of their shock because of having spent an evening with somebody, then the following day they hear that the person is gone. Yet that person was looking good and healthy. Let's be humane. Let's be compassionate. Tuwe na utu kidogo. Tuesday, the heavens are not falling down to join with the earth. I thank you, Mheshimiwa Speaker.
Senior Counsel Paul Mwite, there is a hypothetical question that was raised by Senior Counsel Orengo. Assuming, and it's just an assumption, assuming the Senate is inclined to grant your client up to Tuesday, and by Tuesday, your client is unable to attend Senate, what then will be the way forward?
Mheshimiwa Speaker, I would submit the best thing is for this Honorable House, Honorable Senate, to make a decision on facts rather than assuming what may or may not happen. Point number one. Point number two, Mheshimiwa Speaker, is the importance of honorable senators seeing with their own eyes how a witness withstands cross-examination. There are many times when different impressions will be given by a written document, and yet when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not believable when they see his demeanor in person. So there is nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes completely on the mind of the jury. The Deputy President wishes to subject himself to cross-examination, wishes under oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President we shall believe, or is it those other witnesses? That opportunity can only come through orality and through cross-examination. So what this House elects to do, that decision, this House, Mheshimiwa Speaker, they will make on Tuesday. I am always an optimist. So I am living in the belief that the doctors may be able to put whatever is wrong with the Deputy President back in place so that he can be here on Tuesday, Mr. Speaker. If he's not here, let that decision of what this Honorable Senate will then do be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the Deputy President, as well as the counsel for the National Assembly, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
You are watching live pictures from the floor of the Senate, where the House has briefly adjourned. The Speaker of the Senate is expected to come back and give a ruling on the way forward. The council representing the Deputy President has requested that the team be given until Tuesday, so that the Deputy President can be given the opportunity to be heard before the Senate takes a decision on the impeachment motion that was forwarded to the Senate by the National Assembly. The National Assembly, through its council, has submitted to the Senate that the evidence that was adduced by the Deputy President in writing be considered in this matter. The National Assembly, also through its legal counsel, has also told the Senate that it is willing to forego the cross-examination of the Deputy President, who was to appear as the sole witness in this historic trial in the Senate. The National Assembly did forward to this House 11 grounds of impeachment, which it believes that it has presented enough evidence to warrant the impeachment of the Deputy President. Among the grounds that the National Assembly did advance is the gross violation of Article 10, Sub-Article 2A of the Constitution, and B and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and Article 2B of the Constitution. The National Assembly, in its submission during this trial, did say that the matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic of Kenya, is required to promote constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination and protection of the marginalized, and good governance. It will also respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources, and to promote and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language or birth. In its argument, the National Assembly said that on diverse dates throughout the last 2 years, His Excellency the Deputy President has persistently made utterances threatening to discriminate, exclude and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. In forwarding its evidence to the Senate for the purpose of this trial, the National Assembly did illustrate instances where it believes the Deputy President has been on record committing the said violations. Ground 2, gross violation of Article 147, Sub-Article 1, and Article 152, Sub-Article 1 of the Constitution. The National Assembly states that Article 147, Sub-Article 1 of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152, sub-Article 1 of the Constitution states that the Deputy President is a member of the Cabinet. The National Assembly argues that on various dates throughout the last 2 years, His Excellency, the Deputy President, undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. Under this charge, the National Assembly has moved to illustrate instances and occasions in which it deems the Deputy President to have committed this offence. That on or around 30th of April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. Shortly after that, His Excellency the Deputy President made a public statement opposing the Nairobi River riparian evacuation orders, which the National Assembly argues that the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency the Deputy President made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, the National Assembly argues that His Excellency the Deputy President has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. It has also tried to illustrate that in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency the Deputy President, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. That His Excellency the Deputy President has made numerous other utterances at public forums where he publicly restates the division narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general election. The National Assembly argues that the Deputy President's unilateral, divisive and insightful public statements are impeachable offences to the extent that they undermine the effective discharge of the national government's executive mandate, that they violate the doctrine of collective responsibility, and that they are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Ground 3, gross violation of Article 6, sub-Article 2, Article 10, sub-Article 2A, Article 174, Article 186, sub-Article 1, Article 189, sub-Article 1, and the 4th schedule to the Constitution. This, quote-unquote, undermining devolution. The National Assembly, in its submission in this trial, argues that Article 10, sub-Article 2A of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6, sub-Article 2 of the Constitution provides that government at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions, the National Assembly argues, that are supplemented by Article 189, sub-Article 1 of the Constitution, which provides that governments at each level shall perform and exercise their powers in a matter that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of part 2 of the 4th schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, which the National Assembly argues is an essential organ for consultation between the two levels of government. In its submission before the Senate, the National Assembly, through its legal representatives, say that on or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and allocation of markets. Further, the National Assembly argues that His Excellency, the Deputy President, publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, the Deputy President has interfered with the proper discharge of county government's constitutional functions regarding alcohol and control and regulations. His Excellency, the Deputy President's insightful and demeaning public statements and conduct are impeachable offenses to the extent that they undermine devolution. This is according to the submission by the National Assembly, and that they undercut the functional and institutional integrity of county governments. They unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua, according to the National Assembly, has grossly violated Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, and Article 189, Sub-Article 1 of the Constitution, as read with the 4th schedule to the Constitution. Ground 4, the National Assembly accuses the Deputy President of gross violation of Article 160, Sub-Article 1 of the Constitution, which talks about the undermining of institutional and decisional independence of judges. In its submission, the National Assembly argues that Article 160, Sub-Article 1 of the Constitution provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, according to the National Assembly, recklessly and mindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Sub-Article 5 of the Constitution. The Honorable Judge, according to the National Assembly, had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency the Deputy President to forfeit to the state the sum of 200 million shillings, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks, according to the National Assembly, are impeachable offenses to the extent that they undermine the functional and decisional independence of judges. If you're just joining us, these are live pictures from the Senate chambers where the trial has taken a short break. The Speaker has gone to draw a ruling on the way forward for this trial, where the Deputy President has been unable to appear to take to the witness stand. His legal representative, led by Senior Counsel Paul Mwite, has asked the Senate to give the Deputy President until Tuesday next week and thereafter make a decision on the way forward. The National Assembly, through its legal representatives, led by Senior Counsel James Orengo, urged the Senate to consider the evidence that has already been forwarded by the Deputy President. Quoting the law, the National Assembly, through its legal representatives, argued that having forwarded the evidence in writing, there may be no need to have the Deputy President give his account. The team argued that this Senate can make a decision on that, and it is willing to forego the cross-examination of the witness, who is the Deputy President of the Republic of Kenya. So we are waiting for the Speaker to make a ruling on this request by the Council representing the Deputy President. Ground 5 of the that the National Assembly believes is an impeachable offence is the gross violation of Article 3, Subarticle 1, and Article 148, Subarticle 5A of the Constitution, which talks about the breach of the oath of office and allegiance. The National Assembly, in impeaching the Deputy President, argued that His Excellency Rigathi Gachagua's actions and utterances outlined in Ground 1, 2, 3, and 4 constitute a gross violation of Article 3, Subarticle 1 of the Constitution, which requires every person to respect, uphold, and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148, Subarticle 5A of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President that obligates the Deputy President to obey, preserve, protect, and defend the Constitution. There's also serious reasons, according to the National Assembly, to believe that the Deputy President has committed a crime under national law pursuant to Article 150, Subarticle 1B, Part 2 of the Constitution. Under Ground 6, the National Assembly, in its submission, argues that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13, Subsection 1A, and Section 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offence for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offence to use such words or engage in such behavior when, having regard to all the circumstances, ethnic hatred is likely to be stirred up. The National Assembly argues that besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offence when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility,
violence or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, according to the National Assembly, details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13, subsection 1, and Section 62 of the National Cohesion and Integration Act. Ground 7, serious reasons to believe that His Excellency Rigathi Gachagua has committed crime under Sections 45, subsection 1, Section 46, Section 47A, Part 3, and Section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceedings of Crime and Anti-Money Laundering Act. But for the past 2 years, His Excellency the Deputy President has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired, according to the National Assembly, over the last 2 years is incompatible with his non-legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, or Kevin Gachagua, and Keith Ikeno Rigathi, and other close family members and associates as proxies. The National Assembly argues that His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used a number of companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Anytime from now, we will hand you over to the live proceedings of the Senate, where we do expect in a couple of moments the Speaker of the Senate will walk into the chambers to deliver that much awaited ruling on the way forward. The senators are making their way into the chamber, taking their seats, signaling probably the imminent arrival of the Speaker of the Senate. Just a quick recap. The Speaker adjourned the sitting briefly to draft a ruling on the request by the Senior Counsel Paul Muite, representing the Deputy President in this historic trial. The Senior Counsel told the Senate that the Deputy President had fallen ill and he had been in contact with his doctors at the current hospital, and he also did indicate that he didn't speak directly to the Deputy President on orders by the doctors who are continuing to examine the Deputy President. And in response, the National Assembly, through its legal team, argued that they do not need to cross-examine the Deputy President, who was scheduled to take to the witness stand, but the Senate should consider using the evidence presented by the Deputy President in his submission to make a decision. The National Assembly, through its legal representatives, argued that the matter before the Senate has strict timelines, and so it should be dispensed with, and that is the decision that we are now waiting for the Speaker to make. Ground 8 is serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. That His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. The National Assembly has illustrated in its submission to this trial that sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly, according to the National Assembly, said he would present a petition for the removal of the said judge, which he has not done to date. But this was amended during cross-examination yesterday of the mover of this motion, Honorable Ekamas Mwengi Mutuse, who said that he has been made aware that the Deputy President has indeed presented a petition for the removal of the said judge. There on your screen is the clerk of the Senate. And now we await for the arrival of the Speaker of the Senate. Currently the bell is being rung, and we now await the arrival of the Speaker. Ground 9. And there is the Speaker of the Senate, who is now walking into the chambers. This broadcast is brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation.
Order, honorable senators. Let me apologize, I've taken more than the 5 minutes. The matters that had been raised are weighty, but I'm ready with my ruling and I proceed to deliver it. Honorable senators, ladies and gentlemen, as you will recall, before the rise of the Senate at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This included the evidence laid by the National Assembly, including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 1 hour and 55 minutes for cross-examination. When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwite, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had learned that his client had been taken ill. Asked how he proposed that the Senate proceeds, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Counsel for the National Assembly when asked to comment on the circumstances, argued that unfortunate as the situation was, this being a constitutionally time-bound process, it was imperative that pursuant to Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, the proceedings proceed. Now I'll read Rule 11. It provides thus: where the National Assembly or the Deputy President chooses not to appear before the Senate, that fact shall be put on record, and the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Now, honorable senators, it is also noteworthy that Rule 12 provides as follows. Subject to these rules, the hearing of the evidence, once it commences, shall proceed and continue until the Senate conclude the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to 5 p.m. to allow counsel for the Deputy President to report the status of his client. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted doctors at Karen Hospital who were attending to the Deputy President. He further stated that owing to the condition of the Deputy President, he had not been able to access the Deputy President or talk to him. Senior Counsel then proceeded to cite Article 145(6), observing that although the Senate had opted to proceed by way of hearing the matter in plenary, and while Article 145(6) provides for the hearing of the matter by way of special committee, the provision obligates the Senate to accord the Deputy President an opportunity to be heard before a vote is taken on the impeachment charges. He further cited Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, stating that in accordance with the provisions, the Deputy President had chosen to appear and be presented in these proceedings. Counsel for the Deputy President further submitted that the right of the Deputy President to be given an opportunity to be heard under Article 145(6)(b) of the Constitution is not limited by the 10-day timeline otherwise provided for in this matter. In the end, relying on these provisions, Counsel for the Deputy President requested that the Senate adjourns the matter to Tuesday, the 22nd of October 2024, to enable his client time to be attended to by his doctors. In response, Counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the other hand, he noted that the health matters are matters that are beyond human control. However, he noted that the matter at hand was one that was governed by constitutional timelines. Counsel further indicated that Article 145(6) of the Constitution applied to impeachment proceedings in committee and was not therefore relevant to the present proceedings, which had been convened by dint of Article 145(3) of the Constitution. Counsel observed that the dates for the hearing had, by Gazette notice, been set at 16th and 17th of October 2024. Counsel therefore went ahead to observe that His Excellency the Deputy President had robustly participated in the proceedings by filing detailed responses to the allegations as set out by the National Assembly and through various submissions made in the course of the hearing, including cross-examination of witnesses. Counsel then indicated that if any prejudice was to be suffered by the failure of the Deputy President to testify and be cross-examined, this will be on the part of the National Assembly, which had the legitimate expectation of testing the evidence of the Deputy President through cross-examination. Counsel then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Counsel argued that noting the Deputy President had filed detailed responses and had the opportunity to cross-examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forego the cross-examination of the Deputy President and requested that both parties be allowed to highlight their submissions during their closing statements. Senior Counsel James Orengo had similar sentiments and cited Article 145(5) of the Constitution, arguing that the right to appear and be represented include the right to be represented by counsel. He argued that the Senate that the greater duty was to comply with the Constitution, and that the Senate could not accordingly go outside the timelines as set out in the Constitution. It is noted that the present hearing was convened via Gazette Notice 163, Volume CXXV1, dated the 9th of October 2024. Via that Gazette Notice, I appointed Wednesday, 16th October 2024, as the date for the commencement of the hearing, and further that the hearing will run up to the conclusion of the hearing on Thursday, the 17th of October 2024. As presently convened, therefore, today at midnight, unless midnight finds the Senate in the course of division, marks the end of the period for the hearing of the present impeachment matter. As this process is time-bound by the Constitution to be concluded in not more than 10 days, pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday, the 19th of October 2024, the only window open to the Senate, if it so oblige the request for adjournment sought by counsel for the Deputy President, would be to gazette Saturday, the 19th of October 2024 as a further and final day for hearing of this matter. Now, honorable senators, ladies and gentlemen, such a request is not made to the Speaker, but to the Senate, and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday, the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter, this being the last day allowed by the Constitution of Kenya for these proceedings to conclude. Needless to say, if the motion is not carried, the decision of the Senate will be that this hearing continues to conclusion in the manner provided for under Rule 12. In such event, the hearing will continue as set out in the program, with the parties moving to make their closing statements. Now, honorable senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and best wishes for a quick recovery to His Excellency Rigathi Gachagua, AGH, the Deputy President of the Republic of Kenya. Next to the clerk. Now, honorable senators, you have been circulated with the supplementary order paper. That is the order paper that we're going to use from now going forward. Clerk, now, honorable senators, this being a procedural motion, you don't need to give notice. So when the order is read out, the majority leader will be called upon to move. Clerk, call the order, please. Honorable Senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024.
The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2024. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the ground specified in the motion. Whereas by letter reference NA/DLP/TBO/MTS/2024 025, dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, and on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas Vide Kenya Gazette number 137/18, volume C, XX V1 number 163, dated 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 178, and Standing Order number 78 and 79 of the Senate Standing Orders, the Senate also had the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, 17th October 2024, further noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear and give evidence, if any, on grounds for his proposed removal from office by impeachment. Further noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves as follows. 1, to adjourn today's afternoon sitting on Thursday, the 17th of October 2024, and pursuant to Standing Order number 34(4)(c) of the Senate Standing Orders to hold sittings on Saturday, 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 until the conclusion of business in the order paper on that day. In order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Mr. Speaker, this is a self-explanatory procedural motion that, in light of the request of counsel for the Deputy President, this House adjourns until the closest time possible without violation of the Constitution within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from counsel for the Deputy President, Senior Counsel Paul Mwite, is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has the breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, with those very many remarks, I want to request the minority leader, Senator Justice Stewart Madzayo, to second this motion. I thank you. Justice retired Stewart Madzayo. Sorry, my apologies.
Order, honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. It does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana na macho yote katika nchi hivi sasa yanaegezwa katika bunge la Senate. Nataka kumpatia pole sana kupitia kwa wakili ambaye ni senior counsel wetu na ni wakili mkubwa katika Kenya, ndugu yangu Paul Mwite, kwamba yule client wako amekuwa mgonjwa wakati huu. Najua ni ugonjwa ni kitu cha Mwenyezi Mungu. Hatuwezi sisi tukasema ya kwamba mtu hawezi kuwa mgonjwa. Mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole. Senate imempatia pole na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama maseneta ama nyumba ya Senate, kwamba tumpatie nafasi ya yeye akiwa yuko hospitali aweze kuweza kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Now, honorable senators, I'll proceed to propose a question, which is that aware that the National Assembly on the 8th of October 2024 resolved, with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read, with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025 dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas via Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145.3a of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151b and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151b and 2 of the Constitution and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds for the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024. Further, noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145.4 of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday, 17th October 2024, and pursuant to Standing Order 34.4c of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, honorable senators, we have been here before. This is a procedural motion. We rarely debate procedural motions. It's either we agree with it or we don't agree with it. And therefore, with your consensus, I may move to put the question. Very well. I will now proceed to put the question. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145.2 as read with Article 151b and 2 of the Constitution, and Standing Order 65.2 of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas via Kenya Gazette number 131/78, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses of the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024, further noting that the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of the Deputy President must be concluded within 10 days from the date of the hearing of reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves, 1, to adjourn the afternoon sitting of Thursday, 17th of October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon, in which case then we will move to closing statements by the parties. Yes, Senior Counsel Paul Mwite.
Mheshimiwa Speaker, through you, let me recognize the right of this Honorable Senate to decide any issue, any question put to it democratically, which, Mr. Speaker, is what has happened. Arising from that decision of this Honorable Senate, Mr. Speaker, we as the legal team representing the Deputy President are not able to continue appearing without instructions. So we humbly and with a lot of respect take your leave, Mr. Speaker, and the leave of this Honorable House. Thank you.
Now, honorable senators, we shall move to hear the closing statements by counsel for the National Assembly. Clerk, you may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Counsel for the National Assembly, the floor is yours. You have up to 60 minutes.
Thank you very much, Mr. Speaker, sir.
Statement.
On behalf of the National Assembly, we have a total of 4 advocates who would be sharing the time that is allocated to us. Leading the pack, Mr. Speaker, sir, is Senior Counsel Otiende Amolo, to whom I will cede the floor.
Honorable Speaker, Honorable Senators, I thank you. And this being my maiden appearance on this matter, I sincerely hope I did not drive my learned friend and his team away. But Honorable Speaker, Kenya is indeed a mature democracy. We are so mature that, Mr. Speaker, we gave ourselves the most modern constitution in recent history 14 years ago. We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable Senators. Senator Funandi, take your seat. Senator Kipsang, may the Counsel for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this house, you need 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason, while it looks juicy and it looks very good to the gallery to have that intense cross-examination such as we saw of the mover of the motion, Mr. Speaker, it is irrelevant. It is highly irrelevant, and to the untrained eye, they might think you are achieving much, but you are not achieving much. It must be remembered that the impeachment here is of the Deputy President, not the mover of the motion. So however much you discredit the mover of the motion, you do your client no justice when you do not address the substance of what is moved. Mr. Speaker, allow me to refocus on Article 150. Article 150 makes a very important distinction. And I heard the lawyers of the Deputy President saying that, there is precedent. There is no precedent in our courts in terms of impeachment. There is precedent in terms of removal from office of governors under Article 181. The word used is removal. The word impeachment does not appear in Article 181. But when you come to Article 150, two words are used. You can remove the Deputy President first, Mr. Speaker, under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, it's a strict legal process. You have to show and demonstrate that the Deputy President, has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, impeachment is a demonstration of impropriety, of unfitness for office, of it taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment and 2/3 if it succeeds in this house, you translate it to the millions that it represents. In the National Assembly, 82% translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this house is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the Deputy President. And the charge is he made insightful and discriminatory utterances to the effect that only those who voted for the Kenya Kwanza are entitled to resources and positions in government in Kenya. That is the summary of that charge. That charge is contained in ground 1, ground 5, ground 6, and ground 10. I want to submit, Mr. Speaker, that if you find even only that one charge to have been satisfied, then I want to implore the senators to vote yes for all those 4 grounds together. Has it been satisfied? Mr. Speaker, those utterances are admitted by the Deputy President in the documents before you. The meanings of those words in their variety is known to you and is known to Kenyans. The danger in words is something we know in this country way back in 2007. In our neighboring country, Rwanda, we know what words did. I heard the lawyers of the Deputy President suggest that he did not take any action. Under the law, under Article 10, under Article 27, you do not have to take any action. Utterances are enough, because utterances can do the very damage that the Constitution intends not to be done. Mr. Speaker, what is his response to that charge? There are 2. The first one is he was exercising free speech. Mr. Speaker, that is the easiest to dismiss. I invite the senators to look at Article 33, 2D, Roman 2. It is express, and it says, freedom of expression cannot include advocacy for discrimination, and that's what he was doing. What's the second defense? That whatever he was saying is contained in the various coalition agreements under the Kenya Kwanza coalition that were filed and signed before election. Mr. Speaker, with tremendous respect, allow me to remind the Deputy President that this is the Republic of Kenya, not the Republic of Kenya Kwanza. Mr. Speaker, for that reason, you cannot elevate agreements under the Kenya Kwanza coalition above the legislation of this country, above the constitution of this country. Section 13 of the NCIC Act is very clear that those utterances are unlawful, in fact criminal. Article 10 and Article 27 of the Constitution are equally clear that you cannot make such utterances. So to come and say that I uttered them because they are contained in a coalition for one particular political coalition is in fact an admission. It is an admission of violation of the Constitution. And Mr. Speaker, if members wanted one clear admission of guilt, it is this one. It is not denied. The justification cannot stand. And indeed, Mr. Speaker, once one of the senators asked for the justification, and I had the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this august House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology. The clip was paid here. I invite you to look at the 798 pages that he has filed. There is nowhere where he has rendered an apology. So he leaves you in a position where he says, even if he was not impeached, he will continue doing that because in his view, it is justified by the Kenya Kwanza coalition. Mr. Speaker, I invite the honorable senators to find that this ground has been proved and to impeach the Deputy President on ground 1, ground 5, ground 6, and ground 10 for breach of the NCIC Act, Section 13, and breach of Article 10 and 27 of the Constitution. My last point, Mr. Speaker, allegations of corruption. Mr. Speaker, this House has had the various allegations of corruption. You had the very direct evidence of Dr. Mulwa in terms of KEMSA. You had the very direct evidence of the deputy CEO of ESCC. You had the various evidence in terms of Olive Garden, Vipingo, Outspan, and many others. But I will not go there. I will let you assess that, and my colleagues will address that. I want to address one fundamental thing. In your bundle, honorable senators, in volume 2A of the exhibit, you will find reference to a particular court decision. This is the decision on page 60 of 123. That is the decision in Asset Recovery Agencies versus Rigathi Gachagua. This decision was referred to, but I just want to take you directly to the finding on page 77. This was a case that the Asset Recovery Agency filed against the Deputy President. And this case was actually finalized 10 days before the last general election. What did the court find? The court found positively and declared that Rigathi Gachagua was found to have been having funds which were proceeds of crime and therefore liable for forfeiture to the state to the extent of 200 million. Mr. Speaker, it is important to note that in the 798 pages of the document filed by the Deputy President, there is not a single document that shows that this judgment has been set aside, has been compromised, or revoked. In an inquisitorial system, you do not need to restrict yourself. Where there's a judgment produced that shows that you have been found guilty of having proceeds of crime, the expectation would be that you produce a document negating it. The fact that no document has been produced, I invite you to invoke an adverse inference that either there is no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there is good reason why that document was not produced. Why would you produce all the agreements of Kenya Kwanza and produce all sorts of other things except one page of a document that is the most important document? As it is, you do not have any document that shows that this finding was negated. Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it, because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter, they entered some sort of negotiation is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11 on the impeachment. And the ground 11 is insubordination and failure to actually act collectively with the other members of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president and therefore do not apply to the proceedings before this house. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this house, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss whom he has accused of being behind this motion. He would not actually work with the cabinet where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage, and I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the deputy president today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, honorable senators, honorable speaker, sir, I will refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior and that was the deity. He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement in the submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa mungoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, namwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliwachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa ende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais wametoshea kupewa urithi wao. Mheshimiwa Spika, lakini hata kuna tetesi mwingine yuozea kule kwa jela. Mheshimiwa Spika, kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga, mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka stesheni ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa deputy president. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa, na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who've spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the Deputy President of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the Deputy President, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would would be sufficient to impeach such a Deputy President. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir. We are done.
Thank you. Now, honorable senators, I'll refer you to the program. you will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you'll resume your seats.
Thank you very much, Mr. Speaker, sir.
The media and live broadcast has to cease forthwith.